Okay. Monday, the 5th of April, 2021, Civil Court 1 at 9:34 via Zoom before the Honorable Chief Justice, Civil Jurisdiction 2019, number 320, Cheyra Bell versus the Attorney General and others. Mr. Williams for the applicant, Ms. Settler Best for the first to third respondent, and Mr. Horseman for the fourth respondent.
Yes, Mr. Williams.
Yes, good morning, my lord. I appear on behalf of the applicant, Ms. Cheyra Bell, in this matter.
Yes.
Ms. Settler Best from the Attorney General's Chambers appears on behalf of the first through third respondents, that is the Attorney General, the Department of Child and Family Service, and the head of the Civil Service. My learned friend, Mr. Horseman, appears in relation to the fourth respondent, which is the Public Service Commission. My lord, the application before the court is an application for order certiorari in relation to certain decisions that were made to dismiss the applicant from her employment as a result of gross misconduct. My lord, before I get into the substance of the application, I just want to ensure that the court has before it all the requisite submissions of the applicant and the respondents and all the appropriate authorities.
I have the hearing bundle too, which I've looked at. I have your set of authorities, and I've also received some authorities overnight, which I have printed, and I have the submissions of the respondents and the Public Service Commission. I should say, in terms of today and tomorrow, I think we should go on till 11 o'clock. And then at 11 o'clock, we should take a 15-minute break. But don't sign off. Just turn the video on standby. Otherwise, it'll take a long time to reconnect. And then we'll start again at 11:15, and we'll go on till 12:55, 5 to 1. And then we will resume at 2:15 and go on till 3:30. And then we'll take a 10-minute break. And we start again at 3:40, and we'll continue till 5 o'clock. And we'll repeat the same timetable if necessary tomorrow. So you should carry on till 11 o'clock, and we'll take a 15-minute break then.
Much obliged, my lord. I can certainly say that it is not my intention to go through the voluminous pages of the skeleton in as much detail, because the court obviously has. I'm hopeful that the court has had the opportunity to read over some of the submissions contained therein. So it is hopeful, at least on our end, that the matter can potentially conclude today. But that being said, I do want to take the court to my skeleton argument.
Yes.
And at page 1 of my skeleton argument, it just sets out what the orders that we are requesting that this court make. That is orders certiorari in relation to the decision of the Department of Child and Family Service to refer the applicant to the head of the Civil Service for gross misconduct, the decision of the head of the Civil Service to dismiss Ms. Bell for gross misconduct, and the decision of the Public Service Commission to dismiss Ms. Bell's appeal. Additionally, Ms. Bell seeks a declaration that her employment with the Department of Child and Family Services has not terminated, and her employment as a residential care officer continues until such time as she resigns or by some lawful means, or her employment ends by some other lawful means. The background to this application is set out in the Form 86A application seeking leave to apply to this court for judicial review. And that application is supported by the first and third affidavit of the applicant, Ms. Bell. My lord, I think it's necessary just to go over a brief chronology in relation to the current application before the court. And then I just want to address, there's an obvious, what I would call an elephant in the room in relation to a particular legal argument that it appears has not been addressed at all by the respondents. So I just want to briefly touch on that and then proceed through my skeleton argument sequentially and chronologically and are dealing with the breaches as we say that they have arisen. So the background and a brief chronology is set out at pages 2, 3, 4, 5, and 6 of my skeleton argument.
Yes.
So Ms. Bell was employed as a residential care officer in 2014. Some 4 years later, the alleged incident for which we're here today occurred on the 9th of March, 2018. Some 3 months later, that is when the Department of Child and Family Services was notified of the incident taking place, and a child protection referral was sent to the Department of Child and Family Services concerning the applicant and a colleague, Mr. Shane Hollis. The allegation concerned one of being intoxicated while on shift. The 20th of June, the Department of Child and Family Services investigation team, Leon Smith and Maureen True, interviewed 2 mid-teen residents, and they reported the allegations. Ms. Bell was contacted sometime shortly thereafter. During this period of time, and as settled in Ms. Bell's affidavit, she was actually experiencing sickness, and she had to require major surgery. So she was actually out of office during on the 4th of July and the 5th of July when the department was trying to make contact with her. We're just going to skip down to 5.8. On the 17th of July, 2018, Ms. Bell attends the first official investigation meeting with Mr. Leon Smith and Ms. Hassel as her shop steward and Mr. Marcio Hunt. On the 30th of July, 2020, Ms. Bell is interviewed by the investigation team and admits to drinking 1 or 2 alcoholic beverages. Now, the 29th of August, 2018, the investigation team submitted a report to the Department of Child and Family Services, Acting Director, Ms. Renee Brown. In compiling the report, the investigation team spoke with the 2 teen residents at the Youth Development Center and 3 residential care officers. They were unnamed and unknown to the applicant until it was revealed in Ms. Renee Brown's second affidavit. Mr. Hollis, who is the colleague of Ms. Bell, and Ms. Bell herself. The interview team compiled a report based on interviews from witnesses. The report contained a summary of each witness's statements, which were not written in the witness's own words, a summary of the purported conversations of the unidentified witnesses were prepared by the investigation team and sent to the acting director. And I've defined the unidentified witness summaries as witnesses summaries. So I will be referring to that throughout, and the reason why it's defined is settled in my skeleton. The investigation report contained inter alia the following recommendations: that Ms. Bell and Mr. Hollis should be referred for a BARC assessment and counseling around alcohol use and abuse. And there was another recommendation that senior management must determine what actions will be undertaken to address the reported culture of drinking on shift at RTS. On the 10th of September, now this is where obviously some procedural and breaches of natural justice and fairness occurred. On the 10th of December, the acting director sends a detailed letter to the head of the civil service requesting his opinion under the code of conduct on whether the allegations against Ms. Bell should be considered gross misconduct. This letter contained Ms. Bell's name. On the 11th of September, the head of the civil service informed the acting director that the incident concerning Ms. Bell was of sufficient gravity that it should be treated as gross misconduct. The 11th of September, the head of the civil service directed that Ms. Bell be placed on administrative leave. On the 1st of October, Ms. Bell was provided a letter containing a statement of alleged disciplinary offenses. Ms. Bell was not provided with the witness summaries. On the 6th of November, Ms. Bell attended before the department to have a meeting in relation to the allegations of gross misconduct. The only thing that she had before her at that time was the alleged offenses. And she did not have the witness summaries before her. And Ms. Bell answered and spoke to those charges. Ms. Bell didn't have the benefit of any witness statement material. She was completely unaware of the content of the statements made against her and was unable to refute all the allegations made against her.
I mean, this wasn't intended to be a hearing. This was just part of the investigation at this stage.
I do accept that, my lord, and you will see that when I progress throughout my submissions, where there are matters that are in dispute and matters that, notwithstanding the fact that this wasn't a final hearing, that if certain breaches occurred and certain investigations and certain inquiries were not pursued at the administrative level, and it permeates the other levels of the investigation where Ms. Bell was then prejudiced because certain things weren't done, then it's our submission that because certain things weren't done initially, then that breach is a continuing breach, and a breach that was not remedied and could not be remedied in the meeting with the head of the civil service and the PSC.
I mean, there is a question as to whether at this stage the rules of natural justice require that these witness statements be handed over and that depends on whether this is has reached really a hearing stage or whether this is still part of an investigation.
I do accept that, my lord, that the charge sheet and the charges and allegations did reveal a summary of the allegation against Ms. Bell.
Schedule 2 doesn't seem to require. I mean, Schedule 2, it requires just that, i.e., a summary of the charges. Doesn't speak about Schedule 2 doesn't speak about providing witness statements to the respondent.
I accept that Schedule 2 does not speak to providing witness statements, but in this specific case, where you have a summary that was not only provided to the applicant later, but it was that same summary was given to the acting director. The acting director didn't have the witness statements. So the acting director was proceeding on the basis of summaries of unknown, redacted witnesses. So the responsibility of the filtering stage is to ensure that, or to consider the allegations, and this was considered somewhat in the case of the DPP and Cindy Clark. I mean, it just briefly touched on what the purpose of the filtering stage is. And it would be our submission that because the acting director did not have an opportunity to actually see witness statements and didn't have an opportunity to even consider the credibility of those witnesses because the acting director received redacted statements, then the prejudice that resulted from the acting director simply accepting those witness statements without knowing the identity of the witnesses, the prejudice continued throughout.
What do you say to their point that they were under, I'm not sure whether legal obligation, but certainly they thought that they were under an obligation to ensure that the children's identity was preserved, and they thought that if the statements contained their names, that would be spread around because these statements are likely to be circulated to a fairly wide body, that they are under an obligation to ensure that children who are under their care remain anonymous.
Well, that would have been, it's our submission that would have been a decision that should have been properly considered and properly explored with the acting director. That decision wasn't a decision of the acting director. That was a decision of the investigation team.
Do you say that in relation to employment context, that, I mean, clearly, in relation to a criminal proceeding, if you're accused of a criminal offense and one is in the realm of judicial proceedings, um, you are entitled to see the witness statements which have been gathered by the prosecution, and that is provided by statute, but no doubt that would also be as a consequence of rules of natural justice. Do you say that the same particularity applies in the context of an employer-employee relationship?
Well, there may be certain contexts where these issues may not arise, or where the evidence may not be so heavily weighted against the applicant. It's our submission that where you, obviously there are two issues running parallel. There's the issue of the teen children whose identities were unknown. And then that's the issue of the residential care officers whose identities were also kept anonymous. So what we have is, in essence, is 5 witnesses, all of whom their identities have been kept, from the acting director, the head of the civil service, the PSC, and my client. And the credibility of those witnesses is taken and accepted over the credibility of my client, who was the only one that was able to give any sort of oral testimony on the matter. So, although in an employment context, there may be some scope where the rule shouldn't be relied on or applied so strictly. In this particular case, where it amounts to a manifest prejudice to Ms. Bell, and this is what we would say in this case, then she should have been provided an opportunity to consider the witness statements and not witness summaries. And it goes further to one of my arguments that I discussed later on when we deal with what, in any event, was the correct burden of proof that the head of the civil service had to consider in this matter, because the investigation report and the acting director said that Ms. Bell had committed negligence, and she was negligent in her behavior. That negligence under the Children's Act is a criminal offense. So if it's a criminal offense under the Public Service Commission regulations, then the criminal code of conduct and the criminal burden of proof would have to apply. So it's my submission, my lord, that it's all related and it's all intertwined, in that, yes, there are circumstances where a summary might be appropriate, but in this matter, it manifests.
She was provided a summary at some stage. Was she provided a summary of the witness statements before going before the head of public service, Hobbs? I think she was.
She was provided a summary of the witness statements before she went before the head of the civil service.
I mean, this is like the summary of the 2 children and the other staff. Obviously, their names were redacted, but they were provided summaries. Yes.
Well, what she was before the head of the civil service, yes.
Yes. And did she ask for signed copies?
My lord, it's not included in our affidavit that signed copies were asked for. This was obviously a litigant who was, as I think the acting director stated, she wasn't familiar to the disciplinary process.
But she went with the head of the union, the deputy head of the union, and two others. In fact, at the first meeting, the deputy head of the union told her not to say anything. I mean, she was sort of represented.
Well, she was sort of represented, and I think at the first meeting, the head of the BPSU representative said, "Don't say anything until you know the nature of the allegations against you, until you receive anything." And then Ms. Bell went and had a meeting with the acting director without representation. Sorry, Ms. Bell went and spoke with the investigating team without representation. But I do accept that the BPSU representative was there, and there is no expressed request for witness statements. I don't think that that is the be-all, end-all in relation to this matter, because notwithstanding Ms. Bell's failure to request the witness statements, the acting director and the head of the civil service still have obligations to satisfy themselves that certain protections are afforded. And those protections can only be afforded by having the appropriate information before them. This was challenged information. It wasn't that it was accepted, it was challenged at every stage.
Yes, I mean it is I mean, you should show me the cases which help you. I mean, it is the rules are not absolute. It depends on the context. I mean, clearly, as I say, on one extreme in the context of criminal proceedings, one is entitled to see precisely what the witness has said. The defendant is entitled to a copy of the witness statements. On the other end of the spectrum, the respondent is entitled to know what is being said against him or her, so that in order to comply with the rules of natural justice, he can respond to it. And that doesn't necessarily mean that the person needs to have a copy of the witness statements which the other person has or has not gathered. And I would be interested to know as to whether in the context of employment situation, where the employer is considering a complaint or a disciplinary matter against the employee, what is the employer's burden in terms of providing to the other side the evidence, the case against that person? Is it sufficient that the employer says, here is a summary of what is the case against you? For example, is it sufficient that in this case the department provided the 2 or 3 page summary of what the case was against it and provided a summary of the evidence? Or does one has to go further and say, here are the signed statements of the witnesses, and these are the witnesses who are against you, in the context of employment situation?
I do accept that, my lord. It will prove quite difficult to finding an authority in relation to that context. And if we're narrowing it to that point, I think that this argument isn't, obviously the court is looking at it quite narrow now, but I think the argument expands once we realize what took place subsequent to that.
Yes.
So, my lord, I do address the witness statements a little later in my skeleton argument, and I just wish to take the court to those authorities at that time, if that pleases the court.
Yes, that's fine.
Okay. So, my lord, I was just on page 4 and 5 of my skeleton argument, where I had just provided the background that the head of the civil service had requested or had provided an opinion. He said that the matter should be treated as gross misconduct and Ms. Bell placed on administrative leave. We're just dealing with the disciplinary hearing. And then we have the notice that was provided to Ms. Bell after the meeting within the department. And that notice from the acting director said that the matter was being referred to the head of the civil service because of discrepancies between the two accounts. And that did not allow a decision of dismissal. Then 7 days later, there was a letter sent to the head of the civil service. There was a report, or well, it's our submission that there was no report with a recommendation as to the penalty in respect of the charge. The head of the civil service on the 11th of December extended Ms. Bell's administrative leave. And finally, on the 5th of February 2019, Ms. Bell appears before the disciplinary hearing. There are no witnesses that are called or relied on in the investigation report. The head of the civil service did not know the identity of any of the witnesses. The head of the civil service relied solely on witness summaries and the investigation report. The director of the Department of Child and Family Service, Mr. Mabry, did not attend the disciplinary hearing. Ms. Bell's immediate supervisor did not attend the disciplinary hearing.
At that hearing, Mr. Williams, was it clear that two of the witnesses were children?
Was it clear at that time?
Yes. Let's have a look where the statements are.
The statements are contained at both. If you can,
I think Brown 2 is better because it's the better copies. That's a tab 7. I mean here the names are given. I assume that these are the summaries you're talking about, interviews with O'Loughlin and Ray. And I take it that these names were deleted.
Those names were deleted.
But did they? Is this what they had? The summary? That looks like it's actually a statement.
My lord, this is the summary. It's not a statement.
Well, I mean, yeah. I mean, I think that's semantics in the sense that it's a short form, a sort of statement by the person what they saw, isn't it?
This is a typed version of purported notes taken by Ms. Hassel.
Yes. It's in the third form in the sense that it's not the person saying what it is. It's the person who's been told to, yes. But this is what they had. Did at the hearing before Hobbs, did the union representatives or Ms. Bell asked the head of the public service for the identity of these children?
Well, my lord, the identity of the children were not asked for, but and you will see that in I think this first and third affidavit of Ms. Bell, that it was made quite clear early on that this matter was going to be determined on the papers, irrespective of what Ms. Bell had to say.
But I mean, did they say, did they make representations before Hobbs that it was unfair that they should be allowed to examine these witnesses, and you can't have a proper hearing without examining these individuals, the children and the staff who have made these statements?
My lord, it's my understanding that it was mentioned that.
Where do you find that?
My lord, it's not contained in the ruling of the head of the civil service, but it's my understanding that in Ms. Bell's affidavit, that she did mention the fact that she was unable to.
The question I'm asking is whether when she had the hearing before the head of the public service, as to whether she or her representative said, look, this is unfair. We need to know who these individuals are and we need to cross-examine them.
My lord, it's my understanding that the Department of Child and Family Services made it clear they were not giving up the names at that
But
meeting.
my question is different. I mean, my question is, I appreciate that, but we're having a hearing now. This individual is going to decide whether the charge is going to be upheld, and he's going to decide what the consequences are. And I'm asking whether at that hearing, whether the union representatives or Ms. Bell asked the head of public service that the identity of the witnesses should be disclosed and that she should be allowed to cross-examine them.
Hello, that's two questions. In relation to the first one, I understand that it was mentioned.
Well, no, let's be careful. I mean, it's not. I'm not interested in your understanding. I mean, what's the evidence?
The evidence.
Show me where it is.
Just going back through the first affidavit of. If we go to the page 19 of the hearing bundle, which is paragraph 33 and 34 of Ms. Bell.
Yes.
Reading from paragraph 33, I gave my account of what transpired on the shift. At the end of the meeting, Dr. Binns made it clear that using investigation report to make his final disciplinary decision, which I felt made no sense whatsoever. Firstly, the statements were not witness statements, and they did not include a declaration. Additionally, some of the statements did not contain names, and I was unable to determine who made the statements. I disputed and challenged the assertions contained in the report.
No, I understand that, but I mean, what I'm asking is a simple question, Mr. Williams. Did anybody say to Dr. Binns, look, Dr. Binns, this is unfair. We need to sort of we need to know who these individuals are who are making these allegations, and secondly, we need to cross-examine them.
No, my lord. There was no discussion with the head of the civil service that it was unfair, and there was no discussion that cross-examination should have taken place. I think on those two narrow issues, I can say that the answer to your lordship's questions is no to both.
Yes.
Obviously, in Ms. Bell's case would be that notwithstanding, there would be certain obligations on the head of the civil service to ensure that the matter proceeded fairly, especially where there's disputed evidence.
Yes. Yes, thank you.
My lord, after the hearing that took place on the 5th of February, Ms. Bell received a letter via post being notified of the decision that she was summarily dismissed and terminated. Ms. Bell then sent an appeal by submissions to the Public Service Commission, and that was dismissed on the 2nd of April 2019 without a hearing. The PSC affirmed this summary dismissal.
Yes.
My lord, pages 6 through 10 of my submissions basically set out some general principles in relation to the purpose of judicial review.
Yes.
And just prior to going through those submissions, I just wanted to obviously touch on the submissions of what I call the elephant in the room, which is the apparent bias argument. My lord, having reviewed the submissions of my learned friends, there is no evidence to controvert the allegations of apparent bias. I admit I do have to satisfy the court that existed, and there's no case law refuting that matter either.
I'm sorry, my lord, I hate to interrupt, but perhaps my learned friend would also indicate that that was not in their notice of application. So there is a response, it's just, I'm sorry, my lord?
I'm asking Mr. Williams if the ground for judicial review in respect of which leave has been given.
But yes, my lord, and the final ground of judicial review is that the entire process was flawed and was in breach of natural justice. Natural justice has three key.
No, I understand that, but I mean, most of it has been. I mean, when did you first take the point that the head of public service was to be considered biased, not actual bias, but apparent bias?
My lord, the matter first came to my knowledge when we received the second affidavit of Ms. Renee Brown. And that's the only time we can know, because that was the only time where my client was actually made aware that the head of the civil service made an opinion.
So you couldn't possibly have got leave in relation to it if you didn't know anything about it.
But my lord, the issue of actually getting leave, it's and I think that there's established case law in respect of this issue, is that yes, you can get leave in relation to certain grounds, and yes, you can get leave in relation to a wider context.
I mean, all I'm saying is that this is a point which you've developed recently. And so you said you haven't it hasn't been dealt with in the affidavit because it hasn't been raised in the affidavit until very recently. And you developed it in your written submissions, and we'll deal with it. You should develop the argument, and let's see how it goes.
I crave the lordship. Just if I can just comment further in relation to that, my lord. The court has been seized with the matter for some time, and I do accept that your lordship has said that the matter can develop, and we can deal with it throughout the hearing. But the issue of bias is this isn't an issue that is unknown to the respondents. This was an issue that was raised with them in correspondence. So it's not an issue that this is the first time in my skeleton submissions that they've actually seen it. It was actually raised in the affidavit of Ms. Bell some time ago as well. And they were talking about in, I think, 2019.
Yes.
So, my lord, if I can just address the court on obviously the purpose of the judicial review. The purpose of the judicial review process is to provide a set of legal standards to enable people to challenge the lawfulness of decisions by the public bodies and others exercising public functions in conjunction with their duty to act fairly. I don't want to read through the entire summary, but I do want to take the court to the case of Reese and Crean, which is at paragraph 15.
Yes.
And that is tab 10 of the authorities bundle.
Yes.
It says, in recent Crane, for example, there was a staged process for the removal of a judge under the Trinidadian Constitution at the time. 3 stages were recognized. The first stage being the referral by the commission to the president that the question of removal ought to be investigated. The second being the appointment of the president of a tribunal, an investigation by the tribunal, and a report and recommendation to the president. And the third being the president's referral of the matter, having received the report and recommendation to the Judicial Committee. The decision of the commission to represent that the question of removal ought to be investigated was challenged. And it was accepted that there would without doubt be full natural justice protection at the tribunal stage, and at that stage where the president was making his decision, the latter two stages, and it was therefore argued that natural justice requirements could not be implied in the first stage of the process. Now, this is what we were just discussing at the outset of my submissions. The board expressly extended the principles which they laid down to all functions, whether judicial or administrative. They implied natural justice requirements into the first stage before the commission, despite the acceptance that natural justice would apply to the latter two stages. They did this in light of the seriousness of the charge, and our submission is a serious charge, the intended adverse publicity, and the judicial context. Though the board did say expressly that any person who could show serious prejudice based upon similar considerations would equally be entitled. Reading from what Lord Slynn said at page 194, I have 195 in my submissions, but it's 194C.
Yes.
It says, the fact that a representation was made, a tribunal appointed, and the respondent suspended on the basis of bodily infirmity and misbehavior were bound to raise suspicions or conviction that the commission and even the president were satisfied that the charges were made out in a way which subsequent revocations to suspension would not necessarily dissipate. If the respondent had had a chance to reply to such charges and had been given the opportunity to do so before representation was made, this suspicion and damage to his reputation might have gone avoided. If he gave no adequate reply, then the matter could have gone forward without justification complaint on his part. Yes, it's accepted that Ms. Bell did get an opportunity to actually address the acting director at the administrative level, but obviously it's our submission that notwithstanding Ms. Bell's failure to raise an issue on the just receiving the alleged summary charge, that
But I mean, that was a case, this is a case dealing with a judge. This is a case dealing with a judge where under the procedure, somebody has to decide whether the charges should go forward. And in this case, the body which was deciding that, they weren't actually satisfied in the first instance that there was sufficient material that the charges should be laid. They asked for further material. And when the further material was received, they said, yes, it could go forward. This is in circumstances where, of course, the judge is a public person. He was effectively suspended. The Chief Justice said that he's going to have nothing to do, and that was publicized in the country. And it's in that context the Privy Council is saying that it would have been better that the judge in question, who was effectively, the charges were laid against him, if they had asked him, what do you say about these charges? But that is, Mr. Williams, an exception. The important part in this case is, if you look at Lord Leicester's submissions, starting at page 189G, and in particular, the cases of Fennell and the Wangari High School Board and the Wiseman and Boneman, and all the cases cited at page 191 from D to E, they uphold the proposition that there is no need to provide necessarily comply with the strict rules of natural justice at the investigation stage. I mean, this case is very much an exception to the general rule that at an investigation stage, there is no requirement for strict compliance with the rules of natural justice. And that is because a hearing will come when the charges are being determined. And the reason why this case is important is this is a case is an exception, but you got to understand why it's important, why it was an exception. It was dealing with a judge, and the damage was being done to his reputation. And I'm not sure that case has any parallel to this case, but you tell me otherwise.
Well, my lord, I do accept that it is an exceptional case. The parallel that we seek to draw in relation to this case is that this was a matter that was widely publicized at the time. The struggles of the Department of Child and Family Services during this time was widely publicized. Now, in relation to
But I mean, the Privy Council upholds the general principle, which is against you. The Privy Council upholds the general principle that ordinarily at the investigatory stage, the strict rules of natural justice don't apply. I mean, that is the Privy Council. I mean, thank you for providing that.
Lord, I do accept that there are copious authorities that are against me on this point. It's our submission that notwithstanding there's copious authorities that are against me, this particular matter is exceptional because of the public interest that was involved in this case, and also because of the fact that
I mean, that the reason why they implied it in that case was the damage being done to the reputation of a judge. How does that apply to your case?
my lord, I accept that the profession is quite different. I accept that. And obviously, there has been there has been a generational view that judges and certain professions should be held in a higher regard than the ordinary citizen. I do accept that. But it's our submission that even considering the exceptional nature of the case of Reese and Crane, and notwithstanding the ordinary view, that there are circumstances where the failure to deploy natural justice at administrative level can impact the other levels. I do accept that your lordship might not be with me on that point, but it's our submission that if you look at the matter as a whole, that this is a further example of a breach of natural justice.
Yes.
So, my lord, if I can just now get to the main thrust of my submissions, and what I have elected to do in my skeleton is to take the court through the various stages of the process and to highlight a number of what we call procedural breaches and breaches of natural justice that took place. And if we can start at page 10 of my submissions, says the Department of Child and Family Service, the head of the Civil Service, and the PSC failed to ensure that Ms. Bell was provided a fair hearing. Consequently, Ms. Bell's purported termination was unlawful and a breach of natural justice. In light of the authorities above that provided guidance for the legal argument that natural justice should be applied across each and every stage, it may be helpful to the court to consider the breaches of procedural fairness and natural justice in the order that Ms. Bell experienced them as they were raised in the originating notice of motion. The actions of the authority, the administrative leave, this is the administrative leave and the suspension arguments that are raised in relation to Ms. Bell. Now, the acting director, who is Ms. Renee Brown, wrote to request an opinion from the head of the Civil Service prior to the institution of disciplinary proceedings against Ms. Bell. The request in and out of itself doesn't amount to a breach of natural justice. However, the events that transpired after receiving the opinion unfairly prejudiced the investigation against Ms. Bell for the following reasons. The head of the Civil Service provided advice to prosecute Ms. Bell for gross misconduct after making a decision to place her, then made a decision to place her on administrative leave, and we say that's equivalent to a suspension under regulations. And the head of the Civil Service was later the adjudicator of the disciplinary hearing. My lord, the information in relation to the opinion that was provided is actually set out in the second affidavit of Renee Brown. And if we can just go to the exhibit, I believe it's believe it's towards the end of the exhibit. Page 206 of the hearing bundle. Actually, if we can just go to page 203 of the hearing bundle first. And what we have is a letter from the acting director to the head of the civil service, Dr. Binns. And then it says that I'm just going to read some pieces of some portions of this letter dated this 10th of September. It says, good day, Dr. Binns. As you may be aware, there were 4 allegations against Department of Child and Family Services, Residential Treatment Services employees that were reported for investigation to our Child Protection Investigation Team. 1 met the criteria for misconduct, and I believe that was Mr. Hollis, and will be handled by the department in accordance with the PSC regulation procedures. The 2nd did not meet the criteria for child abuse investigation, and there was no substantiating evidence regarding this allegation. However, the discussion regarding appropriate communication with clients is appropriate. Your opinion is sought for the 3rd and 4th matters in reference to gross misconduct. In accordance with the CECC, which I call the Code of Conduct, 7.42, an officer is guilty of gross misconduct if the officer commits a series of acts of misconduct or a single act of misconduct of such gravity that, in the opinion of the head of the civil service, it warrants being treated as gross misconduct. I seek your opinion on the following alleged incidents by 2 Department of Child and Family Service employees who, according to the child protection investigations, are reported to have occurred.
That's not dealing with us. The 7.4.2 is not dealing with us. D is not dealing with us. Isn't that right?
No, my lord. D is dealing with us.
Well, no, well, all right. Well, let's go through with it. I think you'll find that the D is not dealing with us in the opinion of Dr. Binns, but let's go with it.
My lord, the
D is dealing with another employee.
D is dealing with your opinion is being sought for the 3rd and 4th matters in reference to gross misconduct. That is quite clear in the letter. In accordance with, an officer is guilty of gross misconduct. I seek your opinion on the following alleged incidents. So it's in relation to both employee A and employee B, and that's the applicant.
Yes.
The language is quite clear that it's in reference to the applicant.
Yes.
Now, if I address employee B and what is stated in the letter concerning employee B, it says a child protection referral was received. It was alleged that the Department of Child and Family Service employee B was intoxicated while on shift and transported clients in the work van while under the influence of alcohol.
But you see, under what heading she has put the potential breach? Is 742B, not D.
I accept that. And if you go to employee A, it says that the employee A's potential breach is 7.42A.
Well, I mean, this is for this employee, the relevant provision is 7.4.2B.
I accept that, but this wasn't a case where the acting director sought to simply deal with the matter for gross misconduct, because the acting director, it's my understanding of
no, I accept that.
Regulations.
I accept that she did ask the head of public service.
An opinion.
Do these allegations rise to the level of gross misconduct?
Yes.
Right. But what I'm saying is that was in the context of 7.4.2B, because she specifically says that.
Yes, I accept that. Obviously, there are certain prejudicial statements contained within this referral, where it says that there was a report that Ms. Bell was intoxicated and driving, where obviously it's our submission that had no business being there because that allegation was proven to be unfounded.
Well, and he says so in his report, in his finding. I mean, he specifically says that she wasn't driving in the report, in his decision.
Yes, my lord. Yes, my lord. Obviously, this whether or not he says it in his Dr. Ben says it in his decision, does not mean that there was no prejudice.
Well, I mean, I think
that was occurred in relation to the actual opinion that he provided at this stage, that it amounted to gross misconduct, because it later comes on and you will see that the acting director said that she referred it because there was discrepancies in evidence. That's what he told Ms. Bell.
He subsequently he makes a decision that he finds that she wasn't the driver. The driver was Mr. Hollis, but he does consider that it was gross misconduct. I mean,
yes, my lord. I do accept that there is an attempt to remedy or attempt to cure any prejudice that might have occurred at this stage later on. I do accept that, but just because it is cured later on, the issue of Ms. Bell actually being before the head of the civil service, that is something that could not be cured. So whether or not,
I mean, I understand your legal point. I mean, we need to develop that and see what the other side say. I mean, you're saying that he can't be involved in any way in relation to the prosecution. Not the prosecution is the wrong word. In relation to the decision to launch the disciplinary proceedings, and if he's going to be deciding it, and we have to see if that's a good point or not.
My lord, if I can then just return to my submissions.
But I mean, his letter. I mean, his letter is at page 206, and if you look at it, he says, "It is noted that employee A is alleged to have assaulted a child in his care." That doesn't apply it. And employee B is alleged to have been unfit for duty as a result of being under the influence of alcohol or drugs, in possible breach of CECC 7.4.2b. Do you see that? I mean, he has noted that it's under B, and he says, "It is my opinion as head of the service that the incidents are of sufficient gravity that they should be treated as gross misconduct." But you see, he does say that these are allegations on the basis, assuming these allegations are proved. I mean, he's not saying that I have found that this to be the case and you should charge them. He's looking at those as allegations. I mean, you accept that?
I do accept that he's not making a finding under 7.4D.
Yes.
I do accept that.
Or indeed under B, he's simply saying that if these allegations are true, then they would constitute gross misconduct.
And that he was of the opinion that it would amount to gross misconduct.
Yes, that if these allegations are made out. It is noted that it is alleged in both cases. The middle paragraph.
I do accept that it says alleged, and we will deal with what flows from that, because what flowed from that was that Ms. Bell was suspended, and that takes me right back to my submissions. And obviously following the head of the civil service letter to the department, a letter was then sent to Ms. Bell, putting her on administrative leave, which we say in our submissions is equivalent to a suspension.
Well, I mean, let's deal with that, because you've also shown the memorandum of understanding with the union.
Yes, my lord. And there's a memorandum of understanding with the union, and notwithstanding that memorandum of understanding, the memorandum of understanding, it's binding, subject always to it being lawful and it being
No,
consistent.
understand. But I mean, the administrative leave basically means, you know, you you cannot come to work, but the employer can ask you to come to work anytime. For example, you can't go on a holiday, you know, just because you're on administrative leave, because you have to stick around. I mean, that's different from suspension. Because it's quite important to get this right. I mean, where is the letter which, because doesn't it refer to this memorandum, administrative leave?
The letter is contained, I believe,
Because
in
if you look at it, right, if you look at the memorandum of understanding, which is at tab 15,
Mhm.
is specifically for the purposes of facilitating an investigation of the officer's conduct or work performance. So when there is an investigation into an officer's conduct, like for example here, uh, the secretary to the cabinet or head of the civil service, and he's the person who's given the authority, can direct that they be the employee be at administrative leave, and that's what he's done, because that's what's been agreed between the union and the government.
I accept that the memorandum of understanding exists. What is the practical effect of the memorandum of understanding, and how does it differ from suspension under the regulations? Under the regulations, paragraph 26, it says that the head of the civil service may direct that an officer be suspended from duty if they believe the officer has committed a criminal offense and the proceedings for the adjudication of this disciplinary offense involving gross misconduct have been commenced under the Act.
But he wasn't suspended. She wasn't suspended. I mean, where's the letter which sort of gives her administrative leave? Shall we have a look at it?
Sure, we can look at that letter. I accept that the wording of that letter says administrative leave.
Well, I mean, the reason I say that is because the purpose is different. The purpose under the memorandum for administrative leave is to facilitate an investigation of the officer's conduct. This is paragraph 2 of the MOU.
Mm-hmm.
And so that's got nothing to do with anybody committing criminal offenses.
My lord, if we can just turn
My lord, I believe it's at page 58.
Yeah, administrative leave. In accordance with the memorandum of understanding.
Yes, my lord.
Yeah, reviews and investigates allegations of gross misconduct.
And if we go back to the regulations, once your lordship has read that, it says the head of the civil service believes that the officer has committed a criminal offense or a disciplinary offense involving gross misconduct and that suspension is required in the public interest. But proceedings for the adjudication of a disciplinary offense involving gross misconduct has been commenced under this Act. What has taken place is that it's our submission that this is a suspension in the public interest involving a charge of gross misconduct. What they have done now is the MOU has now coined the suspension as administrative leave. Suspension isn't a penalty. Suspension is both and I think that in many circles, suspension has been considered a penalty. Suspension is not a penalty in this specific regulation. Suspension is part of the disciplinary process in the public interest, which is what administrative leave was in this case.
Well, no, I mean, I think administrative leave is an arrangement which has been agreed by the union, and of course, if the union has agreed it, that becomes a term of the contract of Miss Bell. I mean, these pieces of paper are not just without legal effect. If the union agrees an arrangement with the employer, that the collective agreement, the terms of the collective agreement become a term of the individual contract.
Yes.
So you should read this as though this is a term of Miss Bell's contract, the memorandum of understanding. And it's quite clear that it doesn't require the head of the public service, head of the civil service union, civil service, to come to a view at all. It says, let's read it together. The current process by which approval is granted for leave is as outlined in the collective bargaining agreement between the Bermuda government and the Bermuda Public Service Union and confirmed in the Civil Service Code of Conduct. At the present time, provision for granting of administrative leave is not included in either document. So before this, it didn't exist, and this is now something new. Administrative leave, which is a human resource management term, is a general term for the temporary removal of an employee from a job assignment with or without pay to facilitate an investigation of the officer's conduct or work performance. Any emoluments withheld from the officer whilst on administrative leave will be as the secretary to the cabinet or head of the civil service deems appropriate.
Mhm.
And then if you look at the final paragraph on that page, it says the secretary to the cabinet head of the civil service deems it necessary to remove an officer from worksite to enable an administrative review of the officer's conduct or improper work performance. So it's it's not a case where the head of the public service, head of the yes, head of the public service has to come to any conclusion. It is really an aid to investigation before any decisions are made at this stage. And it is important to keep in mind that the Ms. Bell was placed on administrative leave pursuant to this document.
I do accept that Ms. Bell was put on administrative leave pursuant to the memorandum of understanding. What I was hoping to draw a parallel between is the similarities between the administrative leave process and the suspension process under the regulations, which is our submission that there is no material difference other than the language.
Yes. Yes.
My Lord, I just wanted to skip over a few of those paragraphs because I think we've already hashed that argument out and exhausted it. I just wanted to move to.
Well, are you going to take me to Patrick Glenn and the Public Service Commission, or are we going to do that later on? This is in relation to the bias point, or is that a separate point?
That's a separate point that I.
Okay, well, then I'll just go along with your format. Okay.
Crave your lordship's indulgences. Going to. Well, I just wanted to pick it up from paragraphs 26 and 27 before I leave the issues involving the administrative leave point.
Yes.
Obviously, I'm getting the sense that the court is not with me in relation to the evidence with the suspension point and the administrative leave. I'm just wanted to move away from that.
No. Ms. Williams, let me just, you must understand that just because I asked you questions doesn't mean I have taken a view. The reason I ask questions is because I have to write a judgment at the end of it. Yes, and, the only way I can write proper judgment is to actually thrash it out with counsel so I understand what is being said. So just because I sort of put a question to you, you must not assume that I've taken a view. And that's quite important because half the time I don't have a view on that, but I do have questions.
Yes, yes, my lord. I do accept that, and I appreciate your lordship's comments on the matter. Obviously, I suppose for the purposes of the record, it's our submission. Just continuing on that point, if I can just back up a bit, then go to paragraph 24. It says the request, which was the request for an opinion, the opinion that was provided, and the what we have called suspension, or if we accept that administrative leave is equivalent to a suspension, were all done prior to the commencement of the disciplinary procedure set out in the second schedule to the regulations, and was not in compliance with the code nor the regulations for the following reasons. And my lord, that's where I addressed the Public Service Commission regulation guidelines. That's at tab 2 of the hearing bundle.
Tab 2 is the affidavit of Bell.
Sorry, my lord, tab 2 of the authorities bundle. That has the Public Service Commission regulations.
Yes. Which one which one should we look at?
We're looking at 24 first.
Yes.
And then 26.
Yes.
If the court does accept that administrative leave is equivalent to a suspension, then the procedure that would have to be complied with in this particular case is that the second schedule to these regulations states that the procedure to be followed in the adjudication of disciplinary offenses involving gross misconduct. And the second schedule actually sets out when the disciplinary procedure is commences. And if we go to that second schedule that deals with gross misconduct,
yes,
the disciplinary procedure commences upon the head of the department preparing a written statement of the alleged offense and giving a copy to the officer in question.
Where does it say this is when it commences? I mean, I see that paragraph 1 says the head of the department shall prepare a written statement of the alleged offense and give a copy to the officer in question, which was done.
Okay. If we look at 26, then we go to 26 and we're dealing with 26B. It says 26(1)B says proceedings for the adjudication of a disciplinary offense involving gross misconduct have been commenced under this act.
Yes.
What is the procedure? What is the procedure to be followed? If we go back to 24(2), the second schedule to these regulations states the procedure.
Yes, I see.
So it's our submission that the procedure or the hearing commences upon the start of the procedure, which is the head of the department preparing a written statement.
Yes. Just on that, while we have it, you see regulation 25, dealing with standard of proof.
Yes, my lord.
You seem to suggest that the standard of proof is not criminal. Subject to paragraph 2, the standard of proof of a disciplinary proceeding is that required in court that are not criminal, i.e. civil.
Yes. And then if we continue to 2.
Yeah, an act alleged against an officer in disciplinary proceeding constitutes a criminal offense.
Yes.
The officer has not been charged with a criminal offense. The standard of proof in the disciplinary proceeding is it's that required in criminal proceedings. So if it's a criminal offense, then if the charge is a criminal offense, then the standard of proof is criminal.
The standard is criminal. And it's our submission that the allegations against Ms. Bell, which the Department of Child and Family Services categorized as neglect under the Children's Act, it amounts to a criminal offense.
But I mean, the charge against her was that she was intoxicated and unable to do her job. Is that criminal? I mean, that's what she was charged with.
and the charges where the act alleged against an officer in disciplinary proceedings constitutes a criminal offense. Notwithstanding the fact that there is an allegation of intoxication, the issue in this specific matter was unfit for duty by reason of intoxication, resulting in neglect.
But I mean, they didn't say that. I mean, the charges didn't say that. The charges simply said that you were intoxicated and you couldn't do your job.
Which in these circumstances amounted to neglect. That's the failure of Ms. Bell to do her job under the Children's Act. It's our submission would amount to neglect.
Would there be? Let's just think it through. Let's assume that Mr. Hollis was sober, and he was the driver. So the children were not neglected when they were being driven around, because they were being driven around by a sober driver, even though your client was intoxicated and unable to do her job. I mean, presumably she couldn't drive. And when they got to the residential facility, the other staff had arrived, so that the children were still being looked after. They were being cared by other people. So there was no question of neglect, but your client was still intoxicated, if the facts are true, and unable to do her job. So being intoxicated and unable to do the job is not necessarily the same thing as neglect.
I do accept that there are differences between the two. However, in this specific matter, where the allegation is one that she was not only intoxicated, but she was unable to finish her job, which meant caring for the children, it would be my submission that it's one and the same, because the allegation is that other residential care officers had to attend the facility and then take on, I guess, Ms. Bell's responsibilities at the end of her shift. So if Ms. Bell was unable to complete the shift by reason of intoxication,
yes,
that she was neglectful in her duty.
Yes, I see that.
I understand, obviously, your lordship's point that is raised as it relates to the specific act. There isn't an act that is alleged saying that she was negligent. It's unfit for duty. But I don't think that you can separate the two in this specific matter. Because the reason for her termination, in essence, was that, and I think it's clear to clearly stated in the affidavits of Ms. Brown, that Ms. Bell's behavior was amounted to it was so below standard that the children were there and they were in her care, and these are vulnerable children. So the underlying issue is one of is respectfully submitted neglect, which would amount to, we say, a criminal offense. Now, my lord, I just wanted to pick back up on the procedure as it relates to 24 and 26. And obviously, 26 of the regulation says that there is a two-part test in determining a suspension. And the second part of the test is that proceedings for the adjudication of disciplinary offense involving gross misconduct had commenced under this act. It would be our submission that the proceedings for the adjudication of disciplinary offenses had not begun when the opinion was provided, and therefore the heads of civil service and the actual request and opinion were in breach of natural justice.
But I
because
mean,
the correct procedure had not been followed.
the opinion was an odd opinion. I mean, the opinion given was not sure that it's in the regulations that you can write to the head of the civil service. Obviously, they thought they could. I mean, the acting director thought that uh, these are the facts. She wanted some guidance as to whether, in relation to these alleged facts, because obviously these are just allegations until somebody decides whether they're true or not, whether the proper charge is misconduct or gross misconduct. And she was asking the director what it is. And I mean, I'm not sure that a direction by the head of the public service is actually catered for in the regulations. I couldn't see it anywhere.
No, my lord, but the regulations does speak to the code.
Yes. Where's the code? Let me just show me again.
So if you go to the interpretation, it says the code means the conditions of employment. That's at page 3 of the Public Service Commission regulations.
Yes. And
And
yes. And the code defines the gross misconduct at 7.4.2, and you'll see that A is assaulting people, B is unfit for duty as a result of being under the influence of alcohol and drugs, and that's what she was charged with. C is acting fraudulently, and D is important because that's what Justice Gavely referred to, Chief Justice Gavely. Commits a series of acts of misconduct or a single act of misconduct of such gravity that, in the opinion of the head of the civil service, it warrants being treated as gross misconduct.
I will get to the Lake case. Obviously, it's our submission that is your lordship still with me?
Yes.
Okay. Obviously, in relation to the Lake case, it's our view that the opinion was necessary in that case. In our case, what we're saying is that the opinion that was provided in this case amounts to an issue of apparent bias, because the head of the civil service had to turn his mind to whether or not this specific offense, in his opinion, warranted being treated as gross misconduct, notwithstanding that wasn't the charge. Notwithstanding that it wasn't the charge. The issue was, in his opinion, did that one single act amount to gross misconduct? So it's our view that the Lake case is applicable.
You're not concerned with one act or two acts in here, because B specifically provides that if you're unfit for duty as a result of being under the influence of drugs or drinks or drugs, that will do. You don't have to be concerned with whether it's one act or two acts or anything else. If you come within B, tick, and that's it. You don't have to consider
Absolutely.
D.
And perhaps then the director had no business referring the matter to the head of the civil service.
Well, I mean, I don't know why they did, but that's what the acting director thought, that it was sensible to ask the head of the public service as to what the charge should be.
And I think the issue arises because the acting director or the head of the department chose to refer this matter to the head of the civil service, irrespective of the allegations against her. The fact that it was referred, where it clearly provides for, under the code, that if somebody is unfit as a result of being under the influence of alcohol and drugs, that the matter can be treated as gross misconduct. It's our submission, and I deal with it a little bit later on. I see that the break is probably coming up really soon, but the referral and the opinion that was provided amounts to what we call an apparent bias arising. because
Yes, no, I see that. I mean, I've seen Chief Justice Cavely's judgment. I would be assisted actually, if if I mean, obviously there is the statement by Chief Justice Cavely in the judgment
Mhm.
as to whether one could whether you could show me some other cases which deal with that point, either you or Mr. Horseman or Ms. Sadler Best. To what extent can a decision maker, a person who has to actually decide the issue as to whether the employee is guilty of misconduct or not, be involved in the initial investigation stage, and to what extent the decision maker can be involved in deciding what charge to make or not. I mean, I see the statement made by Justice Cavely, but I would be interested to see the root cases which he has in mind, because he doesn't refer to any.
Much obliged, my lord. I think it might be an appropriate time now.
I think it's a as Justice Mirabux used to say, beverage break.
Okay.
We'll take a beverage break. We're obviously non-alcoholic at this stage this morning.
Much obliged, my lord.
Yes.
Not lunchtime yet.
Yes, Mr. Williams.
My lord, before we went for a quick water break, the court had mentioned the case of Lake, and I just want to obviously address that point briefly before continuing submissions.
Yes.
It's our submission that the authorities, although the comments in Lake can be potentially considered overture because the apparent bias issue wasn't necessarily raised by the parties in Lake, we have secured other authorities on the issue, not local authorities, but authorities on the issue. Obviously, the leading case, Porter and McGill, and I think it's another case, Henry, a solicitor, that just deal with issues of.
Yeah, no, I mean, I understand the general point about bias, but it's the issue is slightly more refined. The issue is, I mean, obviously, Chief Justice Cabley says that as a general principle, a person who's going to have to decide the main issue should not be involved in laying charges. I mean, if I can put it that way. And the question I had for you and other counsel is, really, what are the sort of finer points in relation to that? How far can that decision maker go, and how far he shouldn't go? I mean, these general statements are general statements. One needs to actually look at precisely when there's a red line and when the law says you've gone too far.
My lord, just on that issue, we obviously say the red line needs to be drawn here. Obviously, this isn't an issue where necessity arises. There are powers under the regulations for delegation. And it's our submission that the powers in the delegatory powers under the regulations exist for purposes to avoid hearing.
I mean, what do you say to the point that? Sorry, I interrupted you. Please finish.
No, what I was saying is that the the regulations touch on two issues as it relates to delegation. That being the powers to delegate functions in relation to suspensions, and the powers to delegate in relation to disciplinary offenses. It would be
Does it make that distinction, or you making that distinction?
No, it says it under the regulations that the head of the civil service may delegate any of his functions under the regulations, and that's 26 when we're dealing with suspension.
So it could be any power, anything which he is entitled to do, he can delegate it.
Under this regulation,
yes.
So that's under the suspension regulation, yes, he can delegate that to the deputy head. And anything under the disciplinary gross misconduct regulations and the second schedule, he can delegate to the deputy head.
Sorry, just show me where I should look at regulation 28.
When we're dealing with suspension, that's regulation 26.4.
26.4. The head of may delegate any of the functions under this regulation to the deputy head. Yes, I see that. Yes.
And then under the second schedule, which is at the end of tab 2.
Yeah, I've got that.
So it's our submission that the legislators were aware of an issue of bias arising. In order to...
So where is the... oh, I see. Head of the delegate any of the function under this schedule to the deputy head. Yes.
So the issues in this case were obviously apparent to the legislators. That's why these provisions have been included, to avoid circumstances where the head of the civil service is both the prosecutor and the judge. except for the purpose of this matter. This matter was sent to the head of the civil service because the head of the civil service wrote in and provided his opinion to treat it as gross misconduct.
I mean, the Lake case which you referred to, that is dealing, that's specifically dealing with 742D.
I accept that that is dealing with allegations.
And that is because there the code requires the head of the civil service to so certify. Here we're concerned with 7.4.2b, which does not require the head of the civil service to so certify.
I accept that.
So does that make a difference?
It doesn't make a difference in this case because the actions of the department in requesting and obtaining an opinion have impugned the decision. Because in reality, yes, in the Lake case, the head of the civil service was considering a series of misconducts that amounted to gross misconduct. In this case, the head of the civil service considered whether the one single act of intoxication, it wasn't obviously determinative of the point, but it was determinative of the opinion. He considered that one act, whether that one act could amount to gross misconduct. And he said he was of opinion that it could amount to gross misconduct. And then there was a separate issue that was decided before him, but he had already provided his opinion that the act amounted to gross misconduct. He was of the opinion that it amounted to gross misconduct. And obviously we're dealing with the
No, I mean, what he's saying is that if those facts as alleged can be proved, then it is capable of amounting to gross misconduct, yes. And the question really is, I mean, you know, again, to give you an extreme example, in the context of, say, criminal proceedings, clearly those who lay charges, the DPP, cannot be involved in adjudication of the accused's guilt. But that is an extreme situation. On the other hand, let us assume that there is an old-fashioned employer, and the management structure only consists of one person, the owner, and he doesn't trust anybody else. But he has a workforce of, say, 500 employees, and one of the persons has committed acts which the manager, the owner, the employer thinks amounts to misconduct. He tells the in that context, it can only be the person, the owner, the manager says to the employee, you know, I think that you have been guilty of misconduct, and we're going to have a hearing in relation to this. So in that context, I have no doubt that he is entitled to say, these are the charges, Mr. Jones, and we're now going to have a hearing about them. And he's entitled to then be heard, then determine the issue. So, and that's why I was asking you, you know, where are the fine lines in relation to this? You know, in this context, how far can the head of the public service go in terms of giving advice to the heads of department to say, this conduct, if proven, could amount to gross misconduct without having disqualified himself? And it's not, you know, I mean, it seems to me that it's not black and white line, and you know, it's useful to actually see what the cases say. And I will give you leave. I mean, you don't have to take that point as a point where you may want to develop, and you could do that in terms of reply if you wanted to, if there are other cases which you want to cite to me. And I extend the same invitation to Mr. Horseman and Sattler Best, because, you know, it's clearly a point which has to be decided, but I'm not sure that the Lake case is really the definitive statement.
I appreciate your lordship's allowance to give us some time to respond to that query. Obviously, just an initial response would be, I would ask the court to consider the decision of the, I think it might have been your lordship's decision in the, actually it was the decision of the Court of Appeal in the DPP and Cindy Clark matter, where there was issues of necessity. And where there's issues of necessity, where the director, he was the head of the department and he had a responsibility to do certain things, then it would be in the discharge of him, of his natural function to determine whether or not a matter amounts to a disciplinary offense and to deal with an initial disciplinary meeting. You will see that the Public Service Commission regulations doesn't provide for the head of the department to delegate any of his functions in that regard, because it's simply an administrative function.
Well, I mean, one has no idea why the regulation have said they can delegate these functions. I mean, it may well be that one explanation could be simply that he shouldn't be overloaded with work. There's no reason why somebody else can't do it unless the statutory provision provides for it. It could be argued that he has to do all these things. I mean, in this case, it's not there's no requirement that he is disqualified as a result of say, for example, perception of bias. He could simply say, I've got too much work. I'm going to delegate this to my assistant, deputy. I mean, he would be entitled to do that, wouldn't he, Mr. Williams? If he says, it's a Thursday, I've got too much work to do, so I'm going to, in relation to the 3 cases I have to decide, I'm going to delegate to my deputy.
I'm certain that he could do that. It's our case that obviously he should have done that in this case, which is similar to what he has done in other cases, including the Clark case. The Clark case, although the head of the civil service provided his opinion that the act amounted to a serious act amounted to gross misconduct, that matter was actually heard by the deputy head of the civil service. So it's our view that there hasn't been consistency on that point, but there is an appreciation in our submission that there was a realization that this is a real issue of apparent bias that could potentially exist in circumstances where he's already provided his opinion.
Yes. I mean, let me ask you this as a matter of principle. Can he save himself by saying, I form no view in relation to these allegations because these are just allegations. They will obviously have to be considered and proved in the ordinary way. But if these allegations are proved, then in my view, they amount to gross misconduct. Does that disqualify him, you think?
Well, the difficulty is that we're dealing with apparent bias. So the apparent bias issue.
Well, exactly. I mean, the entire conversation is about apparent bias because we're not dealing with actual bias. We assume that the head of public service is not actually biased. So we're dealing with apparent bias.
So I suppose if this is an extreme example, if I went to dinner with let's say a justice, any justice that I asked for an opinion on, these are my, I know I'm appearing before you, and this is the argument. Can I just get what are your thoughts on it?
But if you're appearing before a justice, the justice is not supposed to have dinner with you.
I accept that, but I'm just saying that that's I said it's an extreme example. But if in that example where I've asked for an opinion, then it's our submission that the opinion being provided, it does impugn the fairness and the objective fairness, because obviously it's a legal system where fairness has to be seen to be done. It's not just a matter of okay, this is biased, but what has to be seen to be done. And in my view, the example provided by your lordship, where the acting director or the head of the civil service simply says he forms no view, that may go some way in refuting allegations of bias. But what we have is allegations of bias that were raised in our client's affidavit that are unrefuted.
Sorry, where are these? These are in the second, third affidavit.
Yes.
Yeah.
They're not refuted.
Anyway, have a look at the employment cases. I think you may find that they do deal with it. I have a sense from my younger days that there were cases in relation to this. Let me ask you this. Assume that this is a case of apparent bias. What is the effect of the appellate body?
Well, the effect of the appellate body would be that the appellate body had the duty and responsibility to ensure that the case was properly before them. And in considering the case, if the case was properly before them, they would have to consider each stage in each process.
No, I mean, the question I have is, I mean, we're not necessarily just dealing with the decision of the head of the public service. He made a decision, but then there was an appeal to the Public Service Commission. I mean, as I understand it, your case, you're not saying that the Public Service Commission was biased.
No, we're not saying that the Public Service Commission was biased. We're saying that
given that the Public Service Commission wasn't biased and the Public Service Commission has actually upheld the decision, does that clean the slate?
No, your lordship, and the reason being is that the Public Service Commission, firstly, we're uncertain of the material that was before the Public Service Commission.
Well, it's not a question of material. I mean, your objection, as I understand it, in relation to apparent bias based on the Lake case, is because Dr. Binns was involved in saying, yes, why don't we, that the allegation against the officer should be one of gross misconduct. He was involved in, if I may put it, using the criminal side, laying the charges, and as a result, he should not be deciding it, and that gives the appearance of bias. And that's what Chief Justice Gavely says in the Lake case. But that would not apply to the Public Service Commission. And there is a line of authority which says that assuming there has been a breach of the rules of natural justice, and that means not giving either party the opportunity to make representation, the odi altrum partem rule, or in relation to bias, if the subsequent body is not infected with that defect, then it may well be it's all right. Maybe you should have a look at my decision in a case called Bowden and the Governor of Bermuda, which is at 2019 number 83. It's on the website, and there I'm not saying that it applies necessarily to this case, but I cite some of these cases where how the principle applies. Specifically, I think you should have a look at
Your lordship, I'm just trying to get the title of the case. You said Bowden?
Bowden. Let me just, you don't have to do it now. I think you should do it properly when you get time. It's called Bowden, B-O-D-E-N, against the Governor of Bermuda and the Commissioner of Police. And I did have a paragraph. Yes, right of appeal. And it's from paragraph 43 to 54. And specifically, you'll see that I referred to cases like at paragraph 45, case called Priest and the General Dental Council, and paragraph 46, Fay and Payne and the Governor and the Bermuda Dental Board, dealing with the issue. The Privy Council decision in Priest illustrates the well-recognized principle that complaints about non-compliance with fundamental fair hearing rights, which occur before a statutory tribunal other than the court, which is not itself sufficiently independent or impartial, can be cured where a right of appeal to a constitutional compliant tribunal exists.
Mm.
So have a look at it and let me know. I need your submission as to why, given that the Public Service Commission wasn't infected with that infirmity of bias, why that doesn't give an answer. But have a look at that decision. I mean, sorry to throw it at you, so you don't have to answer it now. You can go and have a look at it and to come back to me, possibly in reply.
Obliged, my lord.
Yes, let's move on.
Lord, and just at the bottom of page 13 of my submissions,
Yes.
and this is where we just briefly touch on the acting director's failure to demonstrate consistency and fairness in her treatment of Ms. Bell. Put simply, the acting director's choice to refer the matter to the head of the civil service for an opinion was a wrongful exercise of her duty and arbitrary in circumstances where more serious actions of Mr. Hollis by drinking and driving was addressed pursuant to misconduct procedures. The acting director's wrongful exercise of her duty leading to a decision to charge Ms. Bell for gross misconduct was carried out improperly and discriminatorily. And at page 14, I addressed the various breaches we say occurred in relation to the acting director.
Yes.
Obviously, we can deal with paragraph 29. Yes, paragraph 29. The gross misconduct procedure is supplemented by the code at paragraph 7.4, and I have just set out that provision, which says that in cases of gross misconduct, the head of the department must send a report in writing to the head of the civil service with a recommendation with respect to the penalty, which would be at the discretion of the head of the civil service. It's our submission that there was no report that was submitted.
So what's the effect of that?
The effect of that is that there is a significant breach of of natural justice and fairness, in that there was evidence that was supposed to be put before the head of the civil service for determination, and there is no evidence.
But I mean, one can see that would be a very strong point if if the head of the civil service was either bound by it or was bound to take it into account. What is the effect when the provision says which will be at the discretion of the Hawks? I mean, he could take it or leave it, or just ignore it.
Absolutely, that he could ignore it. But what can't be done is our submission that where there's mandatory procedures, we can simply bypass those mandatory procedures simply by saying, oh, well, in any event, it's at the discretion of the...
No, I understand that. But are we in a ground where if there has been a procedural impropriety, you have to ask yourself, what is its overall effect? I mean, we don't set aside decisions for any procedural irregularity. There has to be, the court has to form a view as to whether it has an appreciable impact.
Yes.
Why do you say that this has an appreciable impact? My phrase.
But it has an appreciable impact because the acting director and the supervisor in this case, and it's the uncontested and unchallenged evidence of Ms. Bell, and it's stated in there's a series of messages exchanged between the supervisor and Ms. Bell, that the appropriate recommendation for the penalty was one of counseling. Now, we obviously say that this is important as a material consideration for the head of the civil service, whether it relates to the finding of gross misconduct and whether it relates to the decision on the penalty. That's why we submit that this specific recommendation is of importance, because it could have an impact on the decision of the head of the civil service. And absent it, we are uncertain what that decision would have been. This isn't a case where subsequent to this failure, the head of the civil service asked Ms. Brown or asked anybody, what is your views on disciplinary offense or on a disciplinary penalty for Ms. Bell? It wasn't cured at all. And we say that the failure to provide that penalty is that recommendation is a serious breach of the code. Just going to go forward in my submissions a bit, and then I'm going to come back and just deal with that at page 19 of my submissions.
Yes.
Paragraph 36, and I'm reading. It says, in addition to failures above, a fatal flaw to the disciplinary hearing concerned the breach of Code 7.4 of the acting director in failing to provide a report to the head of the civil service following her referral of Ms. Bell to the head of the civil service. It seems self-evident that where a charge under 7.4 of the code is involved, the acting director must, as a precondition to the matter being referred to the head of the civil service, write a report containing a recommendation with respect to the penalty. In light of the decision by Chief Justice Cayley in Lake and Commissioner Public Service Commission, it is submitted that this area is a substantial deficiency in the case against Ms. Bell. Now, I set out some of the relevant paragraphs that I rely on in Lake here under, and
No. That's a different issue. That's dealing with the opinion of the head of the civil service.
I accept that
the head of civil service is an essential component of
that offense. I accept that that is an essential component of that offense. Equally as important, however, similarly, both the component element in 7.42D and the component element in 7.4 is our submission is equally important, because the head of the civil service does not deal with the officer on a day-to-day basis. So the only persons that can actually come and mitigate or and provide a more accurate depiction of the applicant in this case would have been the department. So it's our submission that this can't be just brushed over as a as simply being not substantive. And I just want to read from the Lake decision, and Lake goes on to say that the head of civil service was to provide an opinion pursuant to 7.42D as a precondition for laying or as an essential element for proving the paragraph 7.4D charge before the present proceedings were commenced in December 2014. It was common ground that the requisite opinion was not placed before either. Similarly, in this case, it was common ground that there was no recommendation that was provided, and that is said in the affidavit of Ms. Brene Brown.
Yeah, I mean, as I say, 742D is slightly different because unless you have an opinion, the 742D, the D charge is not made out. It's an essential requirement.
I accept that, and without a recommendation as to a penalty, then you don't have a report. So if there's no report that is submitted to the head of the civil service, then that is a significant breach. Because the next procedural step is to provide a report, and the report can only be a report if it contains a recommendation.
Did anybody raise the issue as to, why there wasn't a report? Did your client know that there wasn't a report?
Well, at the acting director stage, my client only received what was the charge, which was maybe about 3 or so pages. I think just before or sometime before the hearing, she received a bundle that's contained in her first affidavit. And that's the documents that she received. So at that time, I don't believe the issue was raised. And that may well have been that the issue wasn't appreciated by the BPSU.
Yes, I mean, I was going to ask you because she was being represented at that stage.
Oh, we say represented, and I'm going to actually put represented in.
Well, yes, I mean, not by lawyers, but I mean, but the deputy head of the union, I mean, is presumably familiar with the procedure, and he knows what is important, what is not important.
Oh my Lord! Unfortunately, on that point, it appears that many people don't know what is important and what isn't important, because the acting director didn't provide a report of recommendation. Our client did not obviously identify it, and the head of the civil service did not identify it either.
Was there a point of appeal before the Public Service Commission?
The points of appeal before the public service. This wasn't a point of appeal before the Public Service Commission. The Public Service Commission appeals centered on the issue of whether or not there was proof to say that there was intoxication.
Can you take that point before me in judicial review proceedings, a point which you haven't taken before the appellate body?
Well, my Lord, it would be our submission on this specific issue that as I said, obviously it wasn't appreciated by the BPSU, but what transpired before the appellate body was a further and continued breach. So no, it was not raised in court. It was not raised in correspondence, but the appeal submissions did request that the entire matter be reviewed and the entire matter be heard and investigated. So no, it was not flushed out, and I cannot say whether or not it would have arisen, but the request was made for the entire matter to be reviewed. And in reviewing it, the head of the Public Service Commission, even though they didn't allow for a hearing, if they were just simply going to decide this matter on the papers, they should have reviewed to ensure that the procedure was at least complied with.
But you have to ask, I mean, it's an appellate body. You have to take the grounds. And I mean, if this was such an important point, I'm just curious as to why this wasn't a ground of appeal, that the head of the public service did not have before him the report under paragraph 7.4. And the reason I ask that, these are, you appreciate the point I made earlier, these are judicial review proceedings. Mm-hmm. I'm not here to substitute anybody's opinion. I'm only here to decide whether what was decided before a particular body was correct or not. Yeah. And one of the points always is that if you can say that a point was missed before the head of the public service,
Mhm.
if that point could be put right before the Public Service Commission, then to some extent that point loses force. I mean, if you could have taken that point before the Public Service Commission, this point, assuming it's a valid point, and the Public Service Commission would have put it right, then you have to tell me how you can come to me and complain.
Well, my lord, the simple nature of the matter is that there's mandatory procedures.
Yes, but I mean, you could have put that mandatory procedure correct if you had taken that point before the Public Service Commission.
It would be our respectful view that
Well, so a bit more homework for you. Maybe you should address me, and you can do it in against. Don't want to push you. Is as to whether you can take point before me, which you have not taken before the appellate body. And I think there are, I suspect there are cases which deal with that.
yes, my lord.
Okay.
All right, my lord, just returning to the skeleton argument, and just going back to why we say that notwithstanding the discussion that just materialized, that issue is important. I just deal with that at page 20 in paragraph 37. That the recommendation on the penalty was a critical aspect of the report, and without the recommendation, then the report could not have been completed. From there are two separate issues that arise in relation to the acting director's failure to provide a report. Did the acting director simply refer the matter to the head of the civil service because the head of the civil service already provided his opinion that it amounted to gross misconduct, and therefore she didn't do a proper inquiry and do her own independent assessment?
Yes.
And in relation to that, we rely on the letter that was sent to Ms. Bell saying that this matter was being referred due to discrepancies between the evidence. Obviously, when the matter was at a department level, those discrepancies could have been further explored by way of requesting a further investigations to be undertaken by the investigation team, and then a matter, and then the decision or the matter come back before the acting director, and the acting director then make some sort of determination. But what the acting director did in this case is that, notwithstanding the obvious discrepancies in evidence, she simply performed the act of Pontius Pilate and just washed her hands of it and said, we're just sending this up to the head of the civil service. The second issue that arises under the failure to provide a report is that the unchallenged evidence of Ms. Bell is that the acting director and her immediate supervisor believed that the appropriate penalty was counseling and not termination. Given the unchallenged evidence that the acting director thought Ms. Bell's actions merited a penalty of counseling and not a penalty for gross misconduct, she should have been dealt with under the misconduct procedure and not gross misconduct procedure. So that's why we say that the recommendation is important, because if the acting director is suggesting that
that's just hearsay evidence. By you produce some WhatsApp messages. I mean, is there anything from the acting director that's what she thought was appropriate?
My lord, there's nothing from the acting director, but this was set out in Ms. Bell's first affidavit. So the uncontested and undisputed evidence is that this is what, for the purposes of this hearing, it's our submission that the uncontested and undisputed evidence of Ms. Bell should be accepted.
But I mean, ultimately, this was a decision for the head of the public service. I mean, the issue of what the penalty should be was addressed to him. I mean, his decision makes it clear that it was addressed to him by the union representatives. I mean, they thought that it should be something lighter, but he disagreed.
Well, my lord, this goes to the issue of whether or not the matter should have been before the head of the civil service in any event. Because if the department thought that the matter should be dealt with by way of a misconduct penalty,
but the department didn't take that view, because the acting director obviously was in two minds as to whether it should be serious gross misconduct or just misconduct, and she took the view of the head of the civil service.
well, the acting director took the view to refer the matter to request an opinion, and then referred the matter, or at least in correspondence to our client, referred the matter without any sort of comments on the acts amounting to gross misconduct. She referred the matter on the basis of discrepancy in evidence. That's what the letter says to Ms. Bell. So it's our view that the decision maker, the acting director, simply was bound or felt bound by the opinion of the head of the civil service, and said that they had to refer it up to him.
Yeah. Well, I mean, I think we're back to that point which we discussed earlier, how far the rules of natural justice apply simply to the question of what to charge. I mean, I fully accept that the rules of natural justice apply in varying degrees in relation to the hearing to decide whether the charges have been made out. But, you know, at the earlier stage as to what should the employee be charged with, I mean, there's certainly different views as to whether the full ambit of rules of natural justice applies at that stage.
Yeah.
Because otherwise one could get into a ridiculous position. You could never actually decide anything, because in order to even to charge, you have to have a hearing. That can't be right.
I as I said, and I think we said that at the beginning of the hearing, is that yes, it is accepted that there will always be, or in these disciplinary matters, that the administrative stage is not the decision-making body, but our case is that the prejudice to Ms. Bell was unable to be remedied at these stages subsequently because of the decisions that were made at the administrative level. Obviously, we just want to deal with the issue of the identity of the witnesses.
Yes.
And you see, this is an issue that is not only is an issue that is both relevant to the acting director and the head of the civil service, and potentially the Public Service Commission as it relates to the anonymous witnesses and witness summaries. At page 16 of my skeleton argument, I'm reading the investigating report contains the witnesses' summaries, which resulted in anonymous hearsay evidence permeating Ms. Bell's disciplinary hearings. Firstly, the witnesses did not request anonymity. So this was a decision that was made solely of the volition of the investigating team.
I thought I read somewhere that the witnesses, leaving aside the children, preferred not to be named because they thought that they might be victimized.
There was a suggestion that one witness,
Yes.
but that has nothing to do with the other witnesses.
But
And
more to the point, did your client or her representative, the union representatives, say that we would like to know the identity of these deponents and we would like to cross-examine them? I thought you said that the answer was no.
On the issue of cross-examination, that is on the issue of cross-examination, we accept that there was no request for cross-examination.
But did you ask, I mean, is there anything in writing which says, you know, it is unfair, you should disclose the identity of these witnesses who are giving evidence against me?
Well, as I said, we have two stages to this. Firstly, at the acting director stage, there was only the charge that was written, so we didn't even know what these witnesses' statements were and who the persons were. At the head of the civil service level,
which is in accordance with Schedule 2.
okay, and at the head of the civil service level, now it is my understanding that the issue was raised, but it wasn't raised as it relates to it being unfair. But the issue was raised, and the
is there anything in the record which shows that the issue being raised that
no, there's nothing in the record.
No.
If I can just continue on the anonymous witness point, as I said, there's one sentence that says, we said it's insufficient for the purpose of satisfying the criteria to allow for anonymous witnesses. Additionally, the statements contain an inherent admission by the investigating team that they removed witness identities for persons that were not in fear. Obviously, it's our submission that yes, there would be policy considerations, but when we're dealing with a serious matter involving somebody's employment and the termination of that employment for gross misconduct, that certain rights should be extended to them. They should be allowed to know the identity of persons, especially in circumstances where those persons have not requested that their identity be kept from the applicant.
I mean, what what difference would it have made if you knew the identity in circumstances where you never asked to cross-examine them? I mean, if the real position is that there was serious discrepancy as to what was being said in the statements and what your client's case was, surely the thing to do was to say, I'd like to examine these people because I don't agree with what is being said.
Well, the acting director identified that there were serious discrepancies. It was the mandatory obligations of the head of the civil service to ensure that the relevant persons and officers under the second schedule appeared at the hearing.
Yeah, but I mean, surely, but if you were complaining that you did not have the right to examine them and you were denied the opportunity to test their credibility and the like, surely the first point is, did you actually ask?
Well, my lord, it's my understanding that
I mean, let me ask you this, can you criticize a tribunal for saying that, can you criticize a tribunal on the basis that you were denied the opportunity to cross-examine the witnesses who gave evidence against you and to test their credibility in circumstances where you never asked to examine them?
well, my lord, if I crave your lordship's indulgence.
Yes.
Thank you, my lord. Obviously, what we have is the record, and the record says that the information came from questionable sources.
Well, I mean, exactly. I mean, I'm looking at page 68, and the head of the public service in his decision records at paragraph 11, Mr. Kevin Grant, Bermuda Public Services Union representative, provided a written statement which was placed on the record. Mr. Grant summarized his written statement as follows. 1. The evidence provided by the two residents of RTS should not be considered given their ages, their relationship to the accused, and their interest in having penalty applied to Miss Bell. 2. The accounts provided by workers present on the night in question is conflicted. The evidence provided by the co-worker C should not be considered as that individual was not present for the alleged events. And D. The evidence provided by Miss Bell's colleagues on the evening in question cannot be relied upon as he lied to the investigators. Now, what he doesn't say is that I'd like to examine them. I mean, this is not a case where he just missed. He clearly thinks that their evidence should not be taken into account, but he doesn't say, look, we have issues with this evidence. I would like to examine them.
Lord, as I said, I accept that there was no request for cross-examination or examination. And in relation to that, I think the mandatory procedures are clear in that, notwithstanding the request to examine and cross-examine, these persons should be in attendance. And the reason—
Well, again, did your client ask that they should be in attendance?
Well, the head of the civil service, in determining what was important to the case and relevant to the case, said has an obligation to invite these persons to attend. So if the head of the civil service was going to rely on the hearsay evidence of the workers A, B, and C, and whomever else, he had an obligation to invite those persons to attend the hearing before him. And more likely than not, those individuals during the course of the hearing would have had an opportunity to say what they wanted to say. And my client would have had an opportunity to refute those allegations. What actually transpired is that there was a very short hearing where the head of the civil service determined that he was going to decide the matter on the papers. And if he was going to decide the matter on the papers, then notwithstanding anything that Ms. Bell had to say and her representatives had to say, cross-examination wouldn't have mattered, and because the head of the civil service said he was going to decide it on the papers.
No, but I mean, Mr. Grant could have said, look, I am representing Ms. Bell, and I have serious issues in relation to this evidence. I want to examine them. I mean, it's done all the time. I mean, in relation to union representatives, they know that if they disagree with a piece of evidence, that they're entitled to examine them. I mean, he didn't ask, and he didn't ask also in relation to when he went to the Public Service Commission. He could have said, I want to have witnesses.
Well, my lord, we know that in the affidavit of Ms. Bell, I believe the representative, Mr. Grant, from the Public Service Commission, mentioned that this is one of the, I think, 4 or so times that he's dealt with a matter involving gross misconduct, 3 or 4 times. It might be that it's his inexperience in this specific, as it relates to matters of gross misconduct, has
Well, the difficulty I have as a judge is you're asking me to vitiate, set aside the decision of the head of public service on the basis that your client was denied the right to cross-examine these witnesses in circumstances where the right was never invoked.
Well, my lord, just on that point, it's. I don't think that the submission is that narrow. I think the submission is in a more broader context, in that there is a mandatory obligation for those individuals to be there. Whether or not they were going to be cross-examined, that's That's one thing, but obviously they were relevant to this case.
Okay.
And the other issue that flows from that is that the redacted witness statements of the 5 witnesses existed at every stage: the acting director level, the head of the civil service, and the public service commission, if the public service commission did truly review the entire matter as a whole. So the issue of anonymous witness and witness credibility is our submission. It's a substantial limb of fairness in this specific proceeding, in that we're dealing with issues where the head of the civil service accepted the credibility of unknown persons on disputed evidence over the viva voce evidence of.
Well, I think that might be putting it too high. I mean, this wasn't a case of was the driver of this car on the night in question Mr. Jones or Mr. Pearman. I mean, in this case, in relation to the substance of the charges, a substantial amount of the evidence was common ground. In the end, in the beginning, having denied that there was any drinking at all, and which in itself is quite serious, to actually give evidence which wasn't true. Miss Bell, in the first instance, denied, as did the other gentleman, that they had been drinking, which, as I say, they are giving evidence, and they lied. And then
Giving evidence at what stage, my lord?
Originally, when she first met the investigator, when she was given the charge, she denied that she'd been drinking, and subsequently she accepted. But the point is that she did accept, in this case, that she had been drinking. This is not a case where there was a diametrical difference in evidence. The substance of what she was charged with, namely that she had been drinking, was common ground. She accepted that she had been drinking. The 2 people who heard her evidence said that she said she had had 2 to 3 kronas. She says, I take issue with that. I only said 1 to 2. Now that's the difference in evidence. So it's not a substantial difference, but the point was that it was common ground that she accepted that she had been drinking. The issue was as to whether she was intoxicated. And in relation to that, I mean, obviously her evidence, assuming she was intoxicated, wasn't worth much, because her evidence was clearly would have been unreliable if she was intoxicated. And the evidence from everybody else, the 2 children and the 3 workers, was consistent that she was intoxicated, and she was giving out the impression of any person who'd had too much and not fit to work.
Oh, that is obviously the argument of the Department of Child and Family Services and the respondent.
No, but I mean,
the evidence is highly contested, and there are significant discrepancies in the evidence. If one highly significant discrepancy in the evidence is the allegations that the teen witnesses, the teen children, heard Miss Bell vomiting, which is a point that has not been adopted or accepted by any of the workers. And this is supposed to have happened in the staff bathroom where the workers were present. And this is supposed to have happened when the Miss Bell's colleague rejected the assertions that she was vomiting. So there are significant discrepancies in the evidence. So the issue of obviously intoxication was huge. Yes, Ms. Bell did admit that she had a drink, but on the evidence that Ms. Bell provided to the court, and unfortunately we don't have the notes, the written notes of Ms. True. What we have is now a summary. The evidence in Ms. Bell is that she she could not remember. However, since that time, she has been, I believe, what is it? She has been, or since the allegations have arisen, she has taken account of how many times she has been drinking and when she goes to football games. And she would estimate that during a football game, she would have between 1 to 3 drinks. And then the investigation team provided that, oh, she, in summary, said that she had, she admits to having multiple drinks.
Yes.
Just want to go to the evidence of Ms. Bell, and that's it's at page 52 of the hearing bundle, but I believe that there may be a second version of the evidence at page that it's a bit clearer, and that is at page 186.
Yes. Yes.
Okay, so just taking it from the bottom of the first paragraph involving Ms. Bell, says Ms. Bell stated that based on the letter received, she's aware that she's being accused of being intoxicated while on shift and transporting residents.
Sorry, where are you?
I'm at page 186, just the second last paragraph of the hearing bundle.
Yes.
Okay. So it says that Ms. Bell, okay, sorry. Ms. Bell stated that based on the letter received, she is aware that she is being accused of being intoxicated while on shift transporting residents. Continuing, social worker Smith asked Ms. Bell if there had been a time where she had been intoxicated on shift. Ms. Bell stated no, but if so, it would have been accidental. Ms. Bell identified that she sometimes attends lunch meetings and might have a glass of wine during those meetings. Continuing on, says Ms. Bell said that she agreed to the estimated date and she had tried to work out the date in her mind. Social worker Smith asked if she and Mr. Hollis transported the residents to the youth group on the above date. Ms. Bell stated that it's protocol to take the residents to the youth group on Friday evenings. It goes on to the next page, and we're talking about Mr. Hollis and Ms. Bell were in attendance at BAA while the residents were at youth group. Ms. Bell said that this information sounds correct. Ms. Bell said that she did not have an alcoholic beverage while at BAA. Ms. Bell reported they collected the residents close to 10 p.m. from youth group. Once arriving at YDC, Ms. Bell said that the next staff coming shift arrived at the facility. So this is close to the time where she took the residents, I think just close to the time when she was due to knock off in any event, maybe some 15 or 10 minutes before. Ms. Bell said that her friend picked her up from work and she left. Smith asked if it's common for someone to collect her from work. Ms. Bell said that sometimes she leaves her bike because she has 2 bikes. At every point at this stage, the acting directors, or sorry, the investigation team had not provided, they knew that they had a logbook that was identifying and would obviously assist in triggering Ms. Bell's mind in relation to this specific offense. And obviously, I said it at the beginning of the hearing that Ms. Bell was coming from, she had surgery not too long ago. So she was out on medical leave for an extended period of time due to a serious surgical matter. Um, and later on in the same interview, when they trigger Ms. Bell's mind as it relates to this specific offense that they are alleging, Ms. Bell accepts that she did drink. So just on the issue of Ms. Bell having lied initially, it's our submission that this is a matter, obviously, of considerable datedness, in that the response that Ms. Bell provided, obviously, once she was triggered with, once she was,
I don't have to decide that issue. I mean,
I-
really, but I think to say that it's, I mean, quite clearly, both of them, Mr. Hollis and Miss Bell, initially denied that they had been drinking, and Miss Bell changed her mind subsequently, and she was going to fess up. There's a discrepancy as to whether she said she had 2 or 3 kronas, or whether, as she admits, 1 or 2 kronas. But what's the difference? And
I
then,
think at this stage, my lord,
but more importantly, she said that Mr. Hollis had scotch, and when she was asked how many, she said multiple.
yes,
So, I
my
mean,
lord. Yes, my lord. I'm just trying to figure out where your
So,
lordship.
I mean, I'm not sure. I mean, I'm not sure where we get to by the fine review of the evidence. I mean, clearly in this case, this wasn't a case of Miss Bell denying completely that she'd been drinking. She accepted she'd been drinking. The only issue was whether she was unfit to work.
Yes, my lord, and obviously it's our submission, and this goes back to why I believe the administrative process is important, because the administrative level, they actually referred it for gross misconduct, whereas the more serious conduct was dealt with by way of misconduct. That's our submission. And had the acting director and the investigation team completed a proper inquiry where they would have tested out issues of whether or not there was vomiting, because I'm certain that the issue of vomiting had a huge impact on determining whether or not she was unfit for duty. But those matters weren't properly explored. We have allegations that and findings against Ms. Bell where they've attributed a smell in a car, saying it was musty and smelled like alcohol, and have the civil services attributed that to Ms. Bell, where you have Ms. Bell stating that Mr. Hollis had multiple drinks. So what we have is we have prejudicial comments and prejudicial statements about that were made in general that have now been attributed to solely to Ms. Bell.
Mr. Williams, where's the letter which was given to her to answer the charges by the at the very beginning?
That letter is at page 59 of 59 of the hearing bundle.
Yes.
It isn't the best writing.
That's all right. I can read it. I mean, if you look at the charge, if you consider these as the charges, right?
Mm-hmm.
This is what's given to her, and she says that the second bullet point, the investigation outcome reports indicates that there's evidence on June 15, 2018, that you and your colleagues were on shift together and transported 2 clients to Cornerstone Youth Group. You admitted during the interview that while the residents were at youth group, you and your colleague went to the Bermuda Athletic Club clubhouse. The investigation outcome report recorded witness statements from both residents as well as RCO, who can't read the next word, who came duty for the next shift.
RCO staff.
Yes. Witnesses indicated that you were stumbling when you exited the van. When inside the cottage, you could be heard vomiting. You were also reported to be acting very differently, such as speaking loudly and slurred speech. it was alleged that your eyes were bloodshot and alcohol could be smelt on your breath. When leaving the facility, it was alleged that you were again stumbling and acting out of the character as you are usually reserved in your behavior. Now, those were the allegations made against your client. And then she was given, after the charge sheet, the summary of the witness statements.
She was,
I mean, if she was going to say, I challenge all this, the time to say, I want to test these people and I want to examine them was before Dr. Binns,
well,
or arguably even before the Public Service Commission. I mean, what I find having some difficulty with is that all these allegations were made, and this is the case which is against Miss Bell. It is headed Statement of Alleged Disciplinary Offences.
Mhm.
And one of them is that it was found that you were vomiting as a result of excessive drinking. Now, if she wanted to sort of say, look, I disagree with that, I want to examine the people who say that, who are making these allegations, that was the time to do it. Before Dr. Binns or before the Public Service Commission. I think where I'm having difficulty is that having not said anything before Dr. Binns in relation to examining witnesses or before the Public Service Commission, I'm being asked to set aside these decisions on the basis that, these people should have been cross-examined.
well, my lord, it's two things. Firstly, is the issue of cross-examination, and then it's our submission that it would be the actual need for the court to ensure that the process was fair in any event.
Absolutely, the process was fair. You are absolutely right. We're concerned with process and procedure. And if you come to me and say, Judge, we asked to examine these witnesses, and they said no, I would you would have a very strong case, and I would have great sympathy for that, because the reason would be that would be a complete procedural impropriety in circumstances where somebody's making a serious allegation against your client. And you say that that is not true, I want to examine you. And if you're denied that opportunity, that would be a breach of rules of natural justice. But
Yes,
it's different when you don't ask.
well, my lord, just on that issue, and it's our submission that equally there would be a serious concern as it relates to breaches of natural justice if an individual appears before the head of the civil service, and the head of the civil service determines that he's going to determine the matter on the papers. So I understand your lordship's point on the issue of cross-examination, but it's our view that the head of the civil service had already predetermined in any event what he was going to do, and that was to decide the matter on the papers.
Well, I think you're shifting your ground. Now you're asking me to conclude that even if you're asked, the head of the public service would have said no. I should assume that. But I mean, how can I, in fairness to the head of public service, assume that?
Well, my lord, the only thing that I agree that it's a bit of a long jump for the court to come to that conclusion. However, it is our view that the decision of the head of the civil service to determine the matters on the papers would have had an impact on, in any event, on cross-examination, and it was made clear quite early in the hearing that that was how the matter was going to proceed. So, notwithstanding the fact that there was no application made. So just want to turn to page 21 and deal with the decision before the head of the civil service.
Yes.
Well, firstly, it appears from the affidavit of Ms. Renee Brown that there might have been certain material that was before the head of the civil service that our client never had. The affidavit of Ms. Renee Brown provides a host of documents contained in the exhibit and that were not provided to Ms. Bell. And Ms. Bell wasn't aware of that until the second affidavit of Ms. Renee Brown was provided to our offices on the 30th of October, 2019.
So, can you identify the documents which you say were not provided to you, which should have been?
The documents include the opinion of the head of the civil service, paragraph 19, RB2.
This is the opinion saying that the proper charge is gross misconduct.
Yes, ma'am. If you look at the Renee Brown, her affidavit at page 154, and the paragraph 16, I'm just reading over from paragraph 16.
Yes.
After review of the report, I asked Senior Program Manager Maureen True, who's responsible for oversight of the investigation team, to have each of the RTS staff who provided witness statements to rehear their statements and, if true, an accurate sign verifying that there was a true, accurate representation of their interview. All signed, and this was provided with my submission letter dated 23rd of November 2018 to the head of the public service, verifying the accuracy of the information that was investigation. And then it refers to pages 17 to 43, and that's the material that was provided to the head of the civil service.
So these statements were actually signed then, were they?
So it appears that the statements of the officers, yes, were signed. Whether or not that was before the head of the civil service, I'm to be honest, under the referral letter to the head of the civil service, there's a list of enclosures, and these summaries are not included.
Yes.
So the summary says, actually, it says the enclosures with the client names have been redacted for confidentiality purposes. So the witness statements, signed witness statements, don't appear to have been sent, although in the affidavit, it says that they were sent.
This is like page 192.
Page 192. Yes.
I see, yes. 193. Oh, I see the interviewing folks also signed them, and the witness.
Yes, they signed it about 2 months after it was written.
Yes.
So,
but presumably the substance of it is the same. It's just now they signed them.
Yes, the substance is the same. Now it's signed.
Yes.
As I said, it's at this stage, although it's suggested in the affidavit of Ms. Renee Brown that it was provided to the head of the civil service, there is actually no, the referral letter does not make mention of it, of that being enclosed.
Well, is there any reason I should disbelieve her?
You disbelieve the affidavit of?
The affidavit of Ms. Brown, when she says that it was so provided.
Well, the only thing that we can go by is what the record says. And the record is that...
well, the record is also her affidavit, which says that she provided them.
Well, if it was provided, then obviously our submission would be that we were entitled to them.
Well, it's the same witness statement except it's signed.
I do accept that, and it's signed with the names of the individuals.
Yes.
So and once again, when it comes to anonymous witnesses, and there was a case that I relied on in relation to that called the Linford Cash, a Linford Cash case, which is an employment of appeals tribunal case, and it talked about circumstances where witness anonymity should be preserved. And that included the informant's statement should be reduced to writing, and it should be in that individual's own writing. What we have is somebody else's view of what that witness said.
I mean, as I understand it, the union representatives or Miss Bill didn't ask for the identity to be unmasked. Was there any particular reason why the union representative didn't ask the identity of at least the staff?
My lord, unfortunately, I was not present before the hearing.
No.
And I obviously can't speak to that, and the record doesn't say anything in relation to that. Obviously, they took issue with certain things that were said by the witnesses, but it doesn't appear that the anonymous witness point was taken.
No. It wasn't taken before Dr. Baines. It wasn't taken before the Public Service Commission.
Yes, and it's still a matter of obviously we're dealing with the credibility of the witness statements and the credibility of the witnesses, and having anonymous witnesses that obviously there is some discrepancy in the evidence. I know that the respondent's case is that there is significant consistency that those individuals should be present, especially when they're officers of the Department of Child and Family Services. If I can just take the court to page 22.
Yes.
And I'm just reading the disciplinary procedure for handling cases of alleged gross misconduct. Says where a case has been referred to the head of civil service under paragraph 3B, he shall conduct a hearing after giving at least 14 days notice. The officer shall appear before the head of the civil service in person and may have a trade union representative or friend to assist him if he wishes. The head of the department shall, mandatory provision, invite the officer's job supervisor and head of the department and any other officers whom he considers relevant to the case to appear before him. Those records are obviously relevant persons and the officers of the officers within the meaning of 6A that should have appeared before him. The head of the civil service shall give the officer full opportunity to be heard. It's our submission that there was not a full opportunity to be heard because the Dr. Bin stated that he was going to decide the matter on the papers. Or shall give the officer full opportunity to be heard or to make representations and shall, after hearing both sides, determine the matter or dismiss the allegation. The evidence of Ms. Bell is that Dr. Binns made it clear that he was going to hear the matter on the papers. And obviously that would have crippled any sort of full opportunity to be heard and make representations.
But I mean, I think we have to be very careful about this, Mr. Williams. I mean, you know, these are quite serious allegations. I mean, the position, as I understand, and I thought we've been through this, that your client actually never asked that they wanted to cross-examine the witnesses.
My lord, I'm not actually revisiting that point. What I'm doing is that there's a mandatory or a directive on the head of the civil service to have these persons or invite these persons to be present.
No, I'm talking about paragraph 7. The head of civil service shall give the officer full opportunity to be heard, to make representation, and shall, after hearing both sides, determine the matter or dismiss the allegation. Are you saying that paragraph 7 wasn't complied with?
well, in relation to this, it's our submission that paragraph 6A follows, paragraph 7 follows 6A, in that in both sides giving their full representations on the matter, it would have included the officers and the head of the department and the
Paragraph 7 is dealing with a different subject matter. The head of the civil service shall give the officer, that is Miss Bell, full opportunity to be heard. Was she given full opportunity to be heard?
You said, why was she given a full opportunity to be heard?
Yes.
Looking at the record, I think the record is clear that Dr. Binns, the head of the civil service, and this is the allegation of the position of our client, said he was going to determine this matter on the papers. So I understand I understand your lordship's question, but it's our view that it still comes back down to what was communicated to the applicant at the time.
I mean, is it your case that you didn't ask to cross-examine these witnesses because Dr. Binns had said that everything's going to be done on paper?
Yes, my lord.
Where is that in your affidavit? I mean, that's a serious allegation. Show me a single document which bears testimony to that proposition.
It's contained in the first affidavit. Says at page 19 of the record and paragraph 33, it says, I again gave my account of what transpired. At the end of the meeting, Dr. Binns made it clear that he was using the investigation report to make his final disciplinary decision, which I felt made no sense whatsoever. First of the statements were not witness statements, and they did not include a declaration verifying the truth of its content. Additionally, some of the statements did not contain names, and I was unable to determine who made the statements. I disputed and challenged numerous assertions contained in the report. Nevertheless, Dr. Binns sought to rely on this challenge hearsay evidence.
But I mean, that doesn't say that you said, I want to examine these witnesses.
No, my lord. That point has been accepted. That wasn't the question that I understand your lordship was raising. I thought the question that your lordship was raising was whether or not there was issues that were taken in relation to this specific witness evidence. And what our view was that the witness evidence was disputed, and that notwithstanding the fact that it was disputed, Dr. Binns said that he was going to decide the matter on the papers. So no, there was no request for cross-examination, but although Ms. Bell made it clear that it was disputed, the head of the civil service said, irrespective of you disputing it, I'm deciding it on the papers, even though I have mandatory powers to invite every person that I consider relevant that is an officer to be present at the meeting. And what we would say was that that decision was a decision that was not exercised appropriately in this specific case because the evidence was disputed. And that's probably as far as I can go with that, my lord.
Yes.
The actions taken by the head of the civil service continue on page 22. The disciplinary hearing before the head of the civil service was in breach of natural justice and procedural fairness for the following reasons. The head of the civil service participated in the prosecution and suspension of Ms. Bell, or administrative leave of Ms. Bell, and then was the sole decision maker in the adjudication. The head of the civil service failed to invite Ms. Bell's job supervisor and the head of the department and any other officers whom he considered relevant to the case. No witnesses were called by the head of the civil service. Consequently, there was no cross-examination conducted, even though the acting director admitted that there were significant discrepancies in the evidence. The head of the civil service did not determine the charge according to the correct standard of proof beyond reasonable doubt is our submission. And the head of the civil service did not afford Ms. Bell the opportunity to provide submissions on the penalty after a finding that she was guilty of gross misconduct. So now I just want to briefly raise, because I think that we're going to lunch shortly.
Yes.
I don't know whether or not it would be an appropriate time before I get into the issue of apparent bias, or should your lordship wish me to continue on that point and then break thereafter?
Well, I mean, up to you. I mean, would you like to break now? Or would you want to carry on for another 5 minutes?
My lord, I think it would probably be appropriate to break. I do know that your lordship had raised some queries in relation to some
Yes.
other cases on this matter that might be an appropriate time to allow me to examine.
Yes, I think we should take a break, and we'll resume at 2:15.
Much obliged, my lord.
Yes, thank you very much. Yes, good afternoon, Mr. Williams.
Yes, good afternoon. My lord, just before the lunch break, I mentioned that I wanted to address the issues of apparent bias.
Yes.
That's set out at paragraph at page 23 of the applicant's submissions.
Yes.
And just reading at paragraph 41 says, on the 10th of September 2018, the acting director wrote to the head of the civil service to request his opinion on whether Ms. Bell's single act of misconduct was of such gravity it warranted being treated as gross misconduct. It's the applicant's case that, having determined that the allegations amounted to gross misconduct, the head of the civil service placed Ms. Bell on administrative leave, and then he determined the matter for gross misconduct. I refer to the leading commentary on the matter as involves conflict of interest, and I've set that extract out at tab 18 of the authority bundles, which reads that an individual who plays a role in the prosecution function should not sit on a disciplinary tribunal in the same case. The tribunal would not be independent and the member would be regarded as a judge in his own cause. But the principle has been applied where the individual has not been personally involved in the decision to prosecute. It's our submission that the head of the civil service was involved in the decision to prosecute. It goes on to read that it has been applied where the individual is either a long-serving and senior employee of the prosecutor or has an executive role. In the cases of juries, the principal authority is on point is Crown and Abdrokov. The cases have partly been decided on the basis of whether the tribunal is independent and partly on apparent bias. Although there's a recent authority on a matter involving it's P and the General Counsel of the Bar, P, a barrister, and I've set out a summary in my submissions where it says the visitors of ends of the court held that there was apparent bias in that particular case, where a lay member of the Professional Conduct and Complaints Committee, which determined whether to prosecute members of the bar against whom complaints had been made, sat on the disciplinary tribunal, notwithstanding that she had personally played no part at all in the decision to prosecute. The visitors sitting on appeal from the tribunal held that the member was, as a member of the committee which decided whether to prosecute, judge in her own cause, and it mattered not what her personal role in the decision to prosecute was. Thus, the tribunal could be regarded as independent. Thus, the tribunal could not be regarded as independent within Article 6, and there was an automatic disqualification. In addition, the visitors found for the same reason that there was apparent bias.
This is, I mean, that is exactly the case in Bermuda in the Court of Appeal in relation to Mr. Julian Hall.
Yes.
In that case, Mr. Michael Mello, who was part of the committee, had said, I mean, yes, but is this our case?
My lord, the case is that the head of the civil service has a role in the disciplinary function as it relates to government employees. His duties in dispensing that role can include providing an opinion on whether or not a single act amounts to gross misconduct or whether a series of acts amounts to gross misconduct. In this case, the witness summaries were provided to the acting director, and the acting director could not decide either way how this matter should be determined, whether it should have been misconduct or gross misconduct. That is quite clear, because if the acting director thought that the matter should be dealt with by way of gross misconduct, she need not ask for the opinion at all. And it was clear that even in the letter that the acting director wrote to the head of the civil service on behalf of Ms. Bell, that the reason for this was because there was discrepancy in evidence. So the decision to actually prosecute Ms. Bell for gross misconduct was solely the decision of the head of the civil service.
Yes.
And therein lies the difficulty with this particular action that was taken by the acting director to request the opinion. I admit it put the head of the civil service in a difficult position, but notwithstanding that, there is an issue that has now arisen of apparent bias, which we say is our submission that it cannot be cured. It resulted in an unlawful decision.
When you say can't be cured, what about the court of the Civil Service Commission decision?
Well, it cannot be cured in this case in relation to what actually took place, because I had a brief reading of the Bowden case that refers to the priest Privy Council decision, and the priest Privy Council decision discusses matters where the bias can be cured in circumstances where there is a full rehearing. In this case, there was no full rehearing.
That's because you didn't ask one.
Irrespective of whether or not it was requested, it's our view that the authority and the lot of authorities that follow priests is in relation to there being a full rehearing.
No, I think the authority, if you look at it, I remember that because I wrote the judgment. The authority says that if the full hearing is available, that is sufficient. Not that the party chooses not to exercise its right. I mean, if you look at that decision in that case, I held that that was sufficient because, in theory, it was open to the respondent in that case, or the applicant, I can't remember the facts, to ask for a full hearing before the Public Service Commission. And on that basis, any technical breach of the rules of natural justice, and that would include apparent bias, in theory would be washed away. I mean, that case, as you know, it was purely theoretical. In that case, no, at that stage, he had a potential appeal to the Public Service Commission.
Mm-hmm.
It was a theoretical analysis, and because it was theoretically open to him, that was sufficient. Anyway,
well, it's open to him. I do accept that it's open to him in the case of in the Bowden case, but
I mean the idea would be that I mean, let's assume for sake of argument that there was apparent bias on the part of the head of the public service because of his earlier involvement in suggesting that the charge should be gross misconduct. The Public Service Commission came to the same view, but without the issue of bias on their part.
Well, there are two schools of thought when it comes to this. The first one is obviously if the decision of the head of the civil service is considered to be biased, and that the decision is unlawful and the decision should be void. So the appeal, firstly, there should be no appeal from a void decision.
No. It doesn't work that way. I mean, those cases are quite clear that a breach of a breach of rules of natural justice is capable of being cured as long as the procedure on appeal has that effect. So, I mean, all those cases we deal with, can it be cured on appeal, clearly work on the basis that it can be cured even if there's been a technical breach. It's not a question of once it's void, it's a nullity and nothing further can be done. Because in that case, we will not be concerned about what is the effect of appeal.
Well, that is one, as I said, that is one school of thought on that issue. There is case law in Bermuda, and it's a case, it's a 1999 case, civil jurisdiction number 44 in the Supreme Court, Bermuda Telephone Company and Telecommunications Commission. And in that case, it was a decision concerning statutory appeal procedures. And the view of the court in that case was the view of puny Judge Dennis Mitchell. It says, in my view, the statutory appeal procedures are not apt to deal with the applicant's allegations. Implicit in the language of Section 25, and this is in relation to it's under the Telecommunications Act, sorry, that the appellant may well be aggrieved by, implicit in the language of Section 25 is the assumption that the decision appealed against is a valid one. So we have an appeal that Ms. Bell has made, and in that appeal, the assumption is that it's a valid decision that was made.
Excuse me, I'm sorry. Could we just, which tab are we at in the authorities bundle?
This is a new matter which I will send to, I just came upon it just shortly before we resumed. And just
that's right. It's the Bermuda Telephone Company and Telecommunications Commission, number 44 of 1999.
Yes, it is.
And did Mr. Justice Mitchell cite the case of Prius and the General Dental Council, which is a Privy Council decision?
Did he cite the decision of Priest?
Yes.
No, my lord.
Did he cite the case of Fay and the governor of and the Bermuda Dental Board, the decision of Justice Cavely, and the Privy Council? Justice Cavely.
No, my lord. That was the decision of the Bermuda Telephone Company. It was a 1999 decision. All those decisions occurred.
Oh, I see. I see. I mean, in Fay, this is Justice Cavely, right? In Fay, Justice Cavely stated at paragraph 35 that the Privy Council decision in Priest, now let's take it slowly, illustrates the well-recognized principle that complaints about non-compliance with fundamental fair hearing rights, which occur before a statutory tribunal other than the court, which is not in itself sufficiently independent or impartial, which is your allegation, can be cured where a right of appeal to a constitutionally compliant tribunal exists. So how is what you're saying consistent with that sentence?
Well, firstly, my lord, it is accepted that there are two schools of thought on this issue.
But I mean, on one side you have Mr. Justice Mitchell, again, obviously have great respect for the judge, but on the other side we've got a decision of the Privy Council. And
my lord, it's our submission that, and a correct decision of the Privy Council, that decision turned on the fact that there was a full rehearing. That the decision didn't turn on whether or not there was the statutory regime existed to cure it. It was yes, the statutory regime existed to cure it, and that regime was actually explored completely. in a full rehearing.
Yes. And you say the fact that you had an opportunity to do so is neither here nor there.
The fact that we had an opportunity to do so obviously identifies that, but the fact that we had an opportunity to do so is important to the context of, I guess, appeals in general. But in this specific case, where there was no full rehearing of the matter, and that the matter was decided on the biased and in the apparent biased decision makers' decision, then we say that that right to or that the appellate jurisdiction could not cure the remedy. I mean, cure the defect that happened prior to the decision being made by that body. What we're saying is that yes, the head of the civil service, in our case, that the head of the civil service displayed apparent bias. Now, with that apparent bias, the matter was then referred to the Public Service Commission, and the Public Service Commission relied on the findings of the head of the civil service. The Public Service Commission did not review independently the facts of the matter and determine the decision on their own. What they did is they reviewed the head of the civil service's decision, which was, we submit, a decision that was already influenced by apparent bias, and determined the matter fully then. So there are two arguments, one as to whether or not Ms. Bell requested a hearing and what was fair in the circumstances, considering that this matter was disputed. And the other issue is, notwithstanding the fair hearing point, did the appellate body base their decision on the biased decision of the head of the civil service? And it's our submission that the position is clear that the determination by the Public Service Commission was based on the decision of the head of the civil service. So there was no full rehearing. There was no independent scrutiny of the evidence. It was evidence that was based on a biased decision. And in circumstances where the Public Service Commission is not conducting their own independent exercise.
Did you have a look at the Fair case by Justice Cavely? Was there actually a rehearing? This is Fair and the governor of Bermuda and the Bermuda Dental Board, 2006, Law Report 65. Just want to see what the facts were in Fair in the context of what the Chief Justice Cavely said at paragraph 35 of his judgment.
If your lordship would just give me just one brief moment, I can pull it up for your lordship.
Yes, I think so can I.
Well, Lord, I see that this is a matter that went to the Court of Appeal. It's
Yes.
Fay without the E, Fay and
Mhm.
Payne, and the Governor Bermuda Dental Board. The citation is Court of Appeal 2006, number 18.
Yes.
Uh,
I think you might have gone to
Actually,
Privy
that
Council as
the Court
well.
of Appeal judgment adds nothing to. I'm just reading it. It adds nothing to the argument. I see the Supreme Court judgment as well. It's 2005, 100.
Yes.
I believe this is a ruling on cost. I actually am not able to locate the actual decision.
Okay. Well, we'll have to look at these decisions. Yes, we can proceed.
So the test for apparent bias is established in the well-known case of Porter and McGill. It's further recently confirmed in the case of the Department of Public Prosecutions and Cindy Clark. Lord Hope, in discussing the test for apparent bias in Porter McGill, set out the well-known test as being rather the fair-minded and informed observer, having considered the facts, will conclude that there was a real possibility that the tribunal was biased.
So what do you say about that? I mean, would you think that a fair-minded, reasonable bystander might say that because the head of the public service said, if these facts are proven, that would support a case of gross misconduct, that because he made that statement prior to adjudicating upon it, that a reasonable bystander would say that he was biased?
My lord, it is our submission that a reasonable bystander would say that the tribunal was biased. And obviously, one can look at that specific statement or that specific letter that was sent to the department, which says that it is my opinion as the head of the civil service that the incidents are of sufficient gravity that they should be treated as gross misconduct.
Yeah, but I mean, you're missing the word alleged.
It is noted that employees A and is alleged to have insulted a child in the care of the director, and employee B is alleged to have been unfit for duty as a result of being under the influence of drug and alcohol.
He's passing those. He's passing his opinion based upon assumptions, on alleged facts. He's not saying they are correct. He says, if these are the allegations, then that would support a case of the. I mean,
Well, it would have
the distinction is this: it would be one thing for him to say, obviously, on the basis of these statements and so on, there is a case of gross misconduct. That's one thing, but it's slightly different when you say, based on the assumption that these are the facts, they would support a charge of gross misconduct. I mean, you see the difference.
I do see the difference. I do see the difference, and that's why the issue is an issue of apparent bias as opposed to actual bias, because it's our submission that the examples provided that your lordship just provided would be an issue where we might be raising an actual bias position, because he's already, well, my lord, just in relation to that, I do see the difference in the examples expressed by your lordship. I don't see that the differences expressed in any way diminish the arguments here. And unfortunately, although these issues were raised in the affidavit of Ms. Bell, there is no response from the head of the civil service, which is a bit unusual in these circumstances where certain allegations have been put that the individual, although it would have been a belated statement to speak to one's mindset, we aren't assisted. This court isn't assisted in any way.
Well, it's a legal argument. I mean, what could he say? I mean, you're saying that because he was sent a letter and because he responded to the letter in a particular way, it has the legal consequence, you say, of apparent bias. I mean, the facts are not dispute. What could he say? I'm not biased? Where will that get him?
Well, my lord, I think that the issue then follows, or the point then follows, that the letter having been sent to Ms. Bell and the head of the civil service having provided his opinion that the alleged acts can amount to gross misconduct, then what I think that we're trying to do, or is to, or the court is trying to do, is to say that the opinion of the head of the civil service is an opinion in relation to the allegations and what the allegations can amount to, where we don't necessarily have the evidence in relation to why the head of the civil service has said it is my opinion that the incidents are of sufficient gravity. I think what and with respect,
well, sorry, why not? I mean, he's been told these are the alleged facts, and he's being asked to give his opinion as to whether, on the basis of those alleged facts, they would come within the category of gross misconduct or just misconduct. I mean, why can't he give that opinion based on alleged facts?
Well, on the alleged facts, he can give his opinion, but when he gives his opinion and then later on adjudicates and just confirms his decision that the acts amount to gross misconduct, then it's our submission that that there's apparent bias that exists.
No, I understand your submission. I mean, yeah.
I understand that that the head of the civil service has the option to do this under the regulations and under the code and the schedule. But in this,
I mean, it's not unusual. He is the head of the public service. I mean, it would not be unusual for a department head to ask the head of the public service what is his view on a particular matter.
And I accept that it's not unusual, but just because it's not unusual doesn't mean that well-established practices should be continued. And I think that this may be, or it's hopefully a catalyst to review the Public Service Commission regulations to ensure that it continues to, or that to ensure that it continues to evolve with current principles on natural justice and procedural fairness, because that is obviously it's a live issue that continues to evolve as we continue to fully explore different scenarios where certain fairness and procedural justice should be applied.
Yes.
So the issue of apparent bias was raised in the Patrick Lake case that we discussed this morning. And in this case, it's a case where the former Chief Justice Cayley at tab 16 states at paragraph 18, and these are obviously over the comments, that An important procedural nuance not addressed in the course of argument should be noted. The power conferred by paragraph 9 of the schedule to the regulations enabling the head of the civil service to delegate his hearing functions to an assistant cabinet secretary may have to be deployed to ensure fairness in any case where the head of the civil service is involved in the investigative phase of disciplinary proceedings. It's our submission that the head of the civil service was perhaps unwittingly, on the acting director's part, involved in the investigative phase of the disciplinary proceeding. And the paragraph continues and it says, in charges under paragraph 7.42D, I accept that there's a difference between charges under 7.42D and a charge of 7.4B. However, the matter was referred to the head of the civil service under 7.42D of the code. It says,
Well, I mean, it is slightly, it's more than just this sort of technical change. Under 7.4.2D, unless there is an opinion from the head of the public service, the constituent elements of paragraph 7.4.2.D are not complied with.
I accept that.
I mean, it's an essential piece of paper without which it will not be gross misconduct.
I accept that.
He has to certify it. In 7.4.2b, he's not certifying it. All he's saying is that it can be gross misconduct.
I accept that he's not certifying it for the purposes of a charge. But what he is doing and what is not different, and there is no difference between the language in the matter, is that he is providing his opinion that the offense amounted to gross misconduct. That's what he has done here in this case. Irrespective of which charge it is, he has decided under 7.42D that the single offense amounted to gross misconduct.
To put it another way, unless he was prepared to give a piece of paper with his name on it, there could be no gross misconduct under paragraph 7.4.2.D.
I accept that.
And in our case, which is 7.4.2b, of course, it is up to the head of the department to say, I am going to charge you for gross misconduct. It was completely unnecessary for the acting head to write to the head of public service, and his opinion, to an extent, was neither here nor there. The acting department, the acting head could have said, well, if say, for example, if the in theory, at any rate, if the head of the public service has said that, in my opinion, it's not, he could still, at least in theories, work on the basis there was gross misconduct. Obviously, that's a theoretical analysis, because if it came back to the head of public service for adjudication, he would say no. But what I'm saying is that his opinion in relation to that was not an essential component of the charge.
That is accepted. That is accepted for the purpose of this case. As it relates to the bias aspect, and obviously, when it came to this specific case, the opinion not being provided, that was one issue that was determinative of this specific case, because as you've identified that there is an element that he needs to provide his opinion. But this specific paragraph isn't dealing with, it's our submission. This specific paragraph isn't dealing with the substantive issue of 7.42D and the opinion. It's dealing with the issue of whether or not an opinion provided by the head of the civil service in disciplinary proceedings could amount to a manifest appearance of bias. If he were to both, and it goes on to opine that the series of acts of simple gross misconduct complained of for the purpose of instituting gross misconduct proceedings and adjudicate a hearing of the relevant charge, whether at liability or penalty stage. And in this case, it's obviously our submission that although the charges are different, he has provided his opinion that the act amounted to gross misconduct for the purpose of instituting gross misconduct proceedings, because the gross misconduct proceedings would not have commenced without him having provided his opinion. Now, my lord, on the issue of bias, it's the applicant's case that the issues actually go a little deeper than just apparent bias, and the actual conduct of the hearing may have amounted to a predetermination of the issues. And we rely on the fact of this case that there is a mandatory obligation to have certain parties before the head of the civil service. The head of the civil service didn't invite them to attend. We don't know why he didn't invite them to attend. No, we did not request that they attend, but there was an obligation to invite them to attend. Ms. Bell appeared before the head of the civil service, and once again, it's not disputed in her that the head of the civil service made it clear to the parties that he was going to decide this matter on the papers. It would be our submission that that would amount to a serious breach of natural justice, in that the apparent bias would definitely emanate from this decision and the actions of the head of the civil service in determining that the matter was going to be decided on the papers. Just I believe the court accepts that obviously that actual bias and predetermination are two separate issues. We do raise them separately, but obviously we rely on the facts as it relates to both apparent bias and predetermination. That the subsequent actions of the head of the civil service in stating at the hearing that he was solely going to rely on the witness summaries before him and not take into account the evidence provided by Ms. Bell, then that amounts to what we say, a clear, at least evidential.
Well, I don't think he said that he wasn't going to take into account what Ms. Bell said.
Oh, it's clear. It's our submission that it's clear on, and it's clearly implied by the suggestion that he was going to determine this matter on the papers.
Well, I mean, it's we're going to go back all over again. I mean, it really was one party which could have put an end to that was for your client and our union representative to say, we would like to examine these witnesses. And if he then said no, then you would come back to me and say, Judge, look, there's been a breach of natural justice.
Oh, my lord, unfortunately, and you know, this is our view. This is one of the roles of judicial review. in that, yes, persons don't always get it right on the first go. But then when we review the decision, we look at things that took place, and we determine whether or not those decisions were irrational, or those decisions were unreasonable, or whether there was a proper inquiry, or whether there was a breach of legitimate expectation. So those are all matters that are considered after the disciplinary hearing already takes place. If everybody was to get it right the first time, then there probably would be no need for judicial review. And I don't mean to obviously talk semantics.
You know that, say for example, if there is a right to have oral hearings or witnesses, say for example, appearing before the Public Service Commission, and if a party doesn't ask for it and then comes to the court and complains that there should have been a public hearing, I mean, the authorities show that it's a very rare case where the court will say, well, yes, we understand that your rights have been breached, because the court works on the basis that if you're going to rely upon procedural irregularities, then the least you can do is actually ask for them.
Well, my lord, just in relation to that point, the evidence is such that, and as I stated to the court, this is a fairly new union rep.
Well, no, I mean, I don't.
My lord, if I could
Excuse me, I don't think the court has. The court would be acting properly to vitiate the decision of the head of public service or the public service commission on the basis that the representative of Mrs. Bell from the public service union was not that experienced. I mean, I don't think that's a legitimate ground.
My lord, I accept that it's not a legitimate ground, but what I can just say in relation to the Public Service Commission is that the precedent had been established that the request for that the request on consideration of gross misconduct, that the PSC would hear an appeal, and that's in Ms. Bell's evidence, and that was confirmed by the BPSU representative, that this was the only case where a similar request that was made, no specific request for a hearing was made at any stage. This was the only case where the government officer was not granted an oral hearing before the Public Service Commission. So it would be our submission on that basis that there had been a process and a procedure that had been established by the Public Service Commission.
I thought the evidence of O'Brien is
Brian?
O'Brien. She's yes, Carlita O'Brien.
Mm-hmm.
Her evidence is that the practice at the Public Service Commission is that unless a party asks for a written, an oral hearing, the practice of the Public Service Commission is always to hear appeals on the record.
Well, we disputed that, and we provided evidence, at least as it relates to circumstances where that did not take place, where there, and specifically involving, and obviously the Public Service Commission has a host of disciplinary matters from different from different unions, but as it relates to the BPSU and gross misconduct, we provided a response to that at Ms. Bell's evidence, at her third affidavit, paragraph 34. And I'm just going to read that paragraph. Says in paragraphs 5 to 7 of Ms. O'Brien's affidavit, she states that there was no request to appear before the PSC that was submitted on my behalf. First, as a layperson, I've never received the procedural rules governing discipline rules to the PSC. and I was not aware that any guidelines existed. Secondly, and most importantly, I spoke with Mr. Kevin Grant, Labor Relations Advisor at the BPSU in relation to these paragraphs. Mr. Grant informed me that since occupying his role in October 2016, he has submitted 4 requests for appeals to the PSC. In each of his 4 appeal submissions, he has never made the request to appear before the PSC. Out of the 4 appeals that he filed to the PSC, the only appellant that did not have an opportunity to be heard before the PSC was the applicant. And then we've provided copies of the letters from the Public Service Commission to Mr. Grant, granting those individuals the opportunity to be heard and to appeal their disciplinary award. So it isn't that every time, or it isn't the case that where someone does not request to appear before the head of the Public Service Commission.
I mean,
they simply determine the matters on the papers.
What should I do when I have the document headed Procedure Governing Discipline Appeals to the Public Service Commission, adopted 17 July 2017, and the first operative paragraph says, all appeals will be decided by a panel of the Public Service Commission. Section 28 of the regulation does not require an attendance in person, and hearings are on the record unless prior permission to appear has been requested and granted. I mean, what do you think the court should do in light of that paragraph?
Well, these rules have to be applied in light of each factual circumstances and in light of fairness. So it would be our view in relation to this, that there may be circumstances where, yes, the rules say this, and yes, the regulations do provide that the appeal can be deducted on the papers of or the vote being present.
Mr. Williams, it says more than that. It says that the appeals will be conducted on the record unless prior permission to appear has been A, requested, and B, granted. And the issue, I mean, you have to tell me, what should I make of the fact that you didn't request a hearing, oral hearing?
Well, my lord would have to consider whether or not, through the practice that was deployed by the Public Service Commission and the BPSU representative, that that practice had not, or the practice and procedure hadn't been adopted, that the requests that were made on these matters would automatically be, given the seriousness of the matters, automatically be given a right of a rehearing. So what I would ask the court to consider is whether or not precedent and a legitimate expectation had arisen in relation to these specific matters.
How can you have legitimate expectation which is contrary to a rule of procedure? There's a written rule which says this is to happen. How can you have a contrary legitimate expectation?
Well, my lord, I won't go so far as saying as saying that it is contrary. What I'm suggesting to the court is that irrespective of what the rules say, if a body decides to conduct its affairs in a manner that is not in compliance with those rules, or not in strict compliance with those rules, and it's conducted itself in that manner on a series of occasions, then that can give rise to a legitimate expectation that that body will continue to extend that procedure or that opportunity to that appropriate body.
Yes.
My Lord, I was just dealing with the case of, the issue of predetermination.
Yes.
It's our submission on that issue that there's a strong prima facie case that the head of the civil service had already determined prior to the hearing what the award and penalty was going to be. And the reasons we say this is because the head of the civil service made it clear that he was going to decide the matter on the papers, and the head of the civil service did not consider the fact that he did not have a recommendation. He did not have a report. It's our submission that although the head of the civil service had the opportunity to disregard the report, or the following of that report was discretionary, the absence of that report is significant. I just want to briefly turn to the mandatory procedures to invite the head of the department, the supervisor, and the relevant officers. Says the regulations under Schedule 2 provide a mandatory procedure that must be followed for disciplinary matters. When Parliament prescribes the manner or form in which a duty is to be performed or exercised, it must be followed.
Yes.
Where a party is entitled to an oral hearing before a decision is taken, which materially affects his rights or interests, he should be entitled to call witnesses to support his case and cross-examine witnesses. In this matter, the evidence was disputed, and the acting director stated that there was significant discrepancies in the evidence. Yet the head of the civil service did not have the relevant officers present at the disciplinary hearing. Obviously, our view on that is, if at the administrative level, there could not be any decision made on which view should be believed, then it's our submission that it will be equally difficult for the head of the civil service to form a view on the basis of witness summaries, which view should be believed, the view of Ms. Bell or the view of the deponent for the witnesses. Sorry. So what happened in Ms. Bell's case? It's our submission that what happened is simply amounted to a fast tracking of the procedure. The court having already determined that Ms. Bell was going to be disciplined for gross misconduct and then being found guilty of gross misconduct, there was no need for the head of the civil service, in our view, to even request persons to attend that could assist the head of the civil service with any relevant information. I refer to the case of the Crown and the application of Evans and Chief Constable of Sussex. That was a case involving a police officer. And it's found at tab 26, a police officer that was disciplined for gross misconduct. It's found at 26 of the authority's bundle. And the issue concerned, in my opinion, a police officer facilitating the purchase of a Class A drug constitutes gross misconduct and falls well below the standards of professional behavior expected of a police officer. I'm just reading at paragraph 2. And then I'm going to turn a few pages over to paragraph 43. And this is obviously on the issue of mandatory procedure and the need for the relevant parties to be before the head of the civil service. At paragraph 43, Paragraph 46. I am satisfied that the interview when read in the round, coupled with Mr. James' letter and the submissions that he made on the 3rd of September 2019, make the claimant's case clear. It is that despite her memory lapse, she did not say the words attributed to her. There is no doubt that the evidence, at least in writing, that I have seen presents a strong prima facie case, but a strong prima facie case is one that may often be tested in oral evidence and under cross-examination to be shown to be rather different from how it looked at the beginning. It is the commonplace experience of anyone involved in litigation in whatever capacity to learn that cases that appear to be open and shut at the beginning frequently look rather different by the end. In the circumstances which obtained on the 3rd of September 2009, recognizing as I do the difficulty of the decision of the Chief Constable had to make, I am nonetheless satisfied that natural justice and the interests of fairness require that the claimant be given an opportunity to test the evidence against her in the full ordinary procedure. Questions of fairness in the end are a matter for this court. That is my conclusion. Obviously, we say
in this case, the Commissioner of Police had asked to examine the witnesses.
I do accept that the Commissioner of Police had asked to examine the witnesses, but in this specific matter,
the operative words are I have seen presents a strong prima facie case, but a strong prima facie case is one that may often be tested in oral evidence and under cross-examination be shown to be rather different from how it looked at the beginning. Now, the only person who could cross-examine in this case was Miss Bell. I mean, obviously, Miss Bell didn't ask for it. Do you go as far as to say that it was the duty of the head of public service to say, Miss Bell, you should consider cross-examining these witnesses?
my lord, I do go so far as saying that, and the reason why I go so far as saying that is because the recommendation from the acting director came with it was clear that the reason she could not decide the matter was because there were significant discrepancies in the evidence.
And you say that he should say that despite the fact that she brought with her 2 union representatives.
I do say that despite 2 union representatives being there, the ongoing denial of the allegations consisted at that stage as well. And it wasn't a matter where obviously the head of the civil service then heard oral evidence from one of the officers. This is a case where the head of the civil service heard no oral evidence. So notwithstanding the fact that Ms. Bell didn't ask for cross-examination, he heard no oral evidence at all from any of the officers in this case. Obviously, the officer's evidence in this case, especially where matters are disputed, would be significant in determining issues of credibility. It's our submission that the issues of credibility are relevant because although the respondent's case may be that there is witness summaries that corroborate the allegation that Ms. Bell was unfit for duty, it's our submission that there are significant and material discrepancies between the two. What we don't know, unfortunately, is which aspect of those discrepancies, or which aspect of the discrepancies between the witnesses may have been determinative of the issue for the head of the civil service. Was it the suggestion that the teen witnesses were reliable witnesses, where we have Ms. Bell stating that they make things up and Mr. Hollis stating that they fabricate things? Was it the issue that the teen residents said that, okay, Ms. Bell, they heard her vomiting, although that was disputed, and that was disputed by Ms. Bell's colleague as well, and it wasn't confirmed with by any of the other workers that were on duty. So I think obviously that, and there are two issues running here. One is an issue of drinking, and one is the issue of whether or not she drank and was unfit for duty, and that these things followed. So let's say that there was that on the basis of that Ms. Bell admitted that she was drinking, that amounted to gross misconduct, solely on the fact that she admitted to having a drink. Would the penalty have been the same, solely on the basis that she had one drink, or was this penalty influenced by the children saying that she was so drunk that I could have taken advantage of her, or by the children saying that that she was so drunk that she was vomiting? I heard her vomiting. There was a number of disputed facts in this case that required, it's our submission, in the interest of fairness, that because Ms. Bell raised the issues as being discrepancies, it was incumbent on the head of the civil service to take the initiative, and in the interest of fairness in this specific case, to explore whether or not Ms. Bell's evidence should be believed over the evidence of an officer whom, for all in cases and purposes, we don't even know if he knew the identity of that officer. And
So how would it work? So you say that he should have explored. He should call them as witnesses, and who would cross-examine them?
well, my lord, if I can go to just want to go to the regulations, and it says that.
Where do I find them again?
This is at Authorities Bundle tab 2.
Yes. Which regulation?
We're looking at the second schedule, which is at 25. It's just at the back of tab 2.
I have that.
25.
Mm-hmm. Which
Where a case
regulation?
where a case has been referred to the head of the civil service under paragraph 3B, he shall conduct a hearing. So, Your Worship, I'm sorry, my lord, I accept that there is no identified procedure. But in conducting a hearing, that hearing would surely be a hearing to actually reestablish or establish what the evidence is for the purpose of the disciplinary hearing. And that would mean that the head of the civil service should be asking questions, or the acting director. It's our submission that the acting director would have to present the case on behalf of the Department of Child and Family Services.
Well, I mean, if you say that he's supposed to be a completely unbiased adjudicator, presumably he just sits back and let the evidence be presented to him. Or do you think that we're now into the sort of the European model where, like the French magistrates, it's for him to go out in the wilderness and find the truth?
Well, my lord, if it's this is a case where, from the applicant's point of view, that the head of the civil service was active to the point of making it clear that he was going to decide this matter on the papers.
Yes, I mean, you can have it just for you can actually have a hearing on papers. I mean, it is a means of communication. Obviously, if in cases where there are real conflicts, parties thrash it out, and that's why I was asking you that obviously cross-examination is an important tool in discovering what the truth is. But who is going to cross-examine here? Ordinarily, it would be Ms. Bell and the two trade unionist representatives.
I accept that Ms. Bell would have been dealing with the cross-examination. But what I also wish to identify to the court is that there is an obligation for the head of the civil service to test the evidence of the witnesses and then to determine issues of credibility, because this came down, a lot of this came down to issues of credibility, where the head of the civil service said that Ms. Bell has reason to come before me and diminished the extent of her actions, but he accepted the evidence of the Mr. Shane Hollis, the colleague of Ms. Bell, when Mr. Shane Hollis had equal opportunity, equal reason, or probably more reason, not to be truthful at any stage. So at the very least, Mr. Hollis being an officer, where he's admitted to, or it doesn't even appear he admitted to lying. He didn't admit to lying at all. He refuted that he lied. Where his evidence is being relied on above our client, and the issues of credibility come into place, that it would be unfair for the head of the civil service to determine that issue solely without hearing from Mr. Hollis.
I mean, it would be unusual, Mr. Williams, you tell me whether I'm wrong, for a person who's actually going to decide the case to start an inquisitorial type of arrangement. I mean, one way of looking at, I say that because then there would be all sorts of allegations of bias against that person, as to whether he conducted the examination properly, whether he called the right witnesses, and whether the appropriate time was allotted to all the witnesses. And it's for that reason, in our system of justice, those issues are left to the parties to decide. And the the person who decides the facts stands aloof and doesn't decide who is to be called and who is to be examined and in what way they are to be examined. Just looking at the point you're making in terms of hearings, paragraph 5 says, where a case has been referred to the head of the civil service under paragraph 3b, he shall conduct a hearing. I mean, conducting a hearing, one way of conducting a hearing is to preside over a hearing and give an opportunity to have the hearing conducted. And that seems to be supported. If you look at next paragraph 6, the officer shall appear before the head of the civil service in person and may have a trade union representative or friend to assist him if he wishes. Yes? So
Yes.
that's Ms. Bell is to be given an opportunity to appear before the HOPS, and if she wants to give evidence, she must be allowed to give evidence, and she can have union representatives, and she did.
Mm-hmm.
Then 6A you referred to. Paragraph 7. The head of the civil service shall give the officer full opportunity. Underline the word full opportunity. Not doing it himself, but giving people the opportunity. Full opportunity to be heard or to make representations. To be heard is when other people are making representations or other people are presenting the case, or to make representations, and shall, after hearing both sides, which give the impression that he's standing aloof, determine the matter or dismiss the allegation. I mean, isn't paragraph 7 consistent with what we all understand to be a hearing, whereby the two parties to a potential dispute come along and say, these are the witnesses we want to call, and these are the witnesses we want to cross-examine, and the trier of facts just sits back and says, well, I'll give you my decision after you have finished.
Well, my lord, I'm not challenging the constitutionality of this provision. What I'm challenging is the procedure that was applied and the conduct of the trial in these proceedings. And it's our submission that the conduct of this trial, notwithstanding the fact that the provisions of the statutory regime exist to allow for fairness to be conducted, this specific matter and how this matter was conducted amounted to unfairness to Ms. Bell. And we say that unfairness has arisen because there was an obligation under the head of the civil service under 6A to ensure that the officers that he considered relevant to appear. So what we have done is essentially, and we've kind of reversed the burden in that Ms. Bell should have made a request for those officers to appear and to be cross-examined. No, those officers should have been there. The head of the civil service relied on each employee, and if he deemed those employees to be relevant, then he should have had them present at the hearing.
But I mean, the primary witnesses were the 2 children and the 3 staff.
Yes, and all of them should, and at a bare minimum, the 3 staff and the co-worker should have been present. They are officers, and they should be present for the purposes of the hearing.
Well, that's an issue which I'm going to have to decide. But I mean,
yes.
Clearly, I mean, if you come along and say, we asked for these witnesses to be present and we were denied the opportunity, you have a good case. And obviously, I'm going to have to decide what is the position where the party doesn't ask to be examined. What are the consequences of that?
Well, my lord, I think it's 2 separate issues. One's an issue of asking to be examined, and the other issue is whether or not they should have been there in the first place. And we say that the mandatory procedure says they should be there.
Where does it say that?
It says the head of the civil service shall invite the officers, job supervisor, and the head of the department, and any other person whom he considers relevant to the case to appear before him.
Yes, but I mean, it's
we say that it's a mandatory provision that he should be inviting the Mr. Hollis, worker A, worker B, the head of the department, who at that time was Alfred Mabry, and Ms. Bell's immediate job supervisor, who was Ms. Shannon. And my lord, I don't think that the reason that this provision exists is to be overlooked and say that okay, well, the applicant didn't request these persons to be there, and because the officer didn't request these persons to be there, that that the judicial review is imperiled. Well, it would be our submission that the legislation obviously identified that when we're dealing with serious matters of gross misconduct that deal with persons' livelihood, that these persons should have the opportunity for this matter to be considered and determined with all the necessary bodies before it, so that the head of the civil service can make an informed decision, not only on the offense, but on the penalty.
Head of the department would ordinarily deal with a case like this.
Yes.
At the time, there was no head of the department because Mr. Mabry was away, and it was dealt by the acting head of the department, yes?
At the administrative level, yes, Mr. Mabry was away.
So shouldn't the right person to be there would be the acting head?
The acting head would be
the matter.
The acting head would be a relevant officer. The acting head would be a relevant officer, yes.
Was
For
she
the
not there?
purposes of that schedule, the acting director will no longer be the head of the department. The head of the department at the stage of the disciplinary hearing was Alfred Mabry, Mr. Mabry.
But
So,
he had nothing to do with this.
well, he oversees the entire department. So
No, I appreciate that, but I mean, as far as when this was being investigated and so on, he wasn't there.
he was there initially, and then he left.
Yes.
But the administrative process at the department level was determined by Ms. Brown.
And was the acting head at this hearing?
The acting head was at the hearing. So, my lord, obviously, you would be considering what sort of impact and what sort of prejudice would be incurred by the acting head being there and the head of the department.
Did Miss Bell and the union representative ask to examine the acting head?
Well, the acting head didn't have anything to do with the acting head made opening submissions based on the hearsay evidence of the investigation report. That's what she said.
Yes.
So the acting head didn't have anything to do with the nature of the allegations, whether or not she was unfit for duty. So no, they did not ask to cross-examine her because she didn't have any material relevant information for the purpose.
Presumably the same would apply in relation to the head.
Well, the same could apply in relation to the head as to whether or not they could have cross-examined. But my submission extends beyond that, in that it goes to the issue of what the appropriate penalty should be.
Was the acting head examined in relation to the appropriate penalty?
Well, the issue, nobody was examined in relation to the appropriate penalty. What happened was that
why not?
Because there was the matter was not considered. The matter of the penalty was not considered at that hearing. The issue at that hearing was simply whether or not Ms. Bell was going to be found. Ms. Bell was guilty of gross misconduct.
I thought the written representations by the union rep did deal with the question of sentence.
The written representations by the union rep dealt with.
Where do I find that?
That is at page 65 of the hearing bundle. To deal with oral submissions. And if we.
So, I mean, just looking at paragraph 8, I see that those who made oral presentations was Renee Brown, the acting director.
Yes.
Miss Bell spoke. Miss Linda Meinzer, the second vice president of the BPSU, and Mr. Kevin Grant, the BPSU representative.
Yes.
See, I mean, last paragraph for Mr. Grant, under paragraph 11, Mr. Grant raised concerns regarding the disciplinary process, given his view that both Miss Bell and her colleague had committed the same offences, but were treated differently. I mean, he seemed to be accepting they were committed offences. Mr. Grant suggested that Mr. Bell's colleague received the benefit of no suspension and remains employed, while Miss Bell faces gross misconduct charges.
Yes, my lord, that is not a submission on what the appropriate penalty should be. That's an identification that there's a difference in treatment.
Penalty is 31 onwards.
My lord, if I may be of assistance, the actual appeal letter is at page 219.
219. Yes.
I don't see how this is.
This is to the Public Service Commission.
That's the Public Service Commission. I don't think this assists the court. The issue before the court is what happened at the head of the civil service level.
My apologies.
Yeah, but I mean, it's yeah.
So
Yes.
there was no discussion as to what the appropriate penalty should have been. And we stated it earlier as it relates to the recommendation, and the recommendation being, in our view, that that the acting director thought that the appropriate penalty was one of contempt. And we say this, we stated this in our first affidavit, where the acting director had an opportunity to respond, and she didn't refute that suggestion.
I mean, the appeal to the Public Service Commission, at least in substance, a great deal is about sentence.
I accept that in substance a great deal is about sentence.
But the Public Service Commission upheld it.
The Public Service Commission upheld a decision based on based on sentence, based on well, actually,
I mean, it's you know, I mean, you
don't know what it was predicated on, but
you are painting the sentence as though, well, I think you do say it's irrational, unreasonable, that it's a first offense. You know, one should never have resulted in dismissal. But it's odd that the PSC, and when you made all these points in the letter from Mr. Grant to the Public Service Commission, they've come to the same view.
well, the Public Service Commission solely relied on, with our submission, they relied on the decision of the head of the civil service.
But the facts are, I mean, this is not nuclear science. The facts are relatively in a short compass. I mean, the facts are simply, this is a lady who joined a sensitive position in the public service, looking after children, has statutory obligations, and she has unblemished career to date, starting out, no previous convictions, no previous issues. She has, as the facts are found, to some extent admitted, she was drinking on the job, and she became intoxicated so that she could not perform a function. I mean, that's all. Those are the facts, nothing else. And the question arises whether, given those facts, a penalty of summary dismissal is appropriate. The head of public service thought it was. It was appealed, and all these points which I have just mentioned were made with great care in the 3-page letter dated 6th of March 2019 from the Assistant General Secretary, Mr. Grant. Surprising, but true, that the Public Service Commission upheld that was the correct decision.
The Public Service Commission upheld that it was the correct decision, but it was based on, obviously, it's our view that it was based on evidence that was provided by the head of the civil service in this decision. And what it would be our submission that an appropriate discharging of the head of the civil service function would have been to extend the investigation beyond the scope of the witness summaries. His failure to do that, obviously, it then leads to a matter where the Public Service Commission is considering Ms. Bell's case in a bit of a vacuum, and that vacuum being the matters that the head of the civil service provided in his decision. Yes, I accept that there are certain basic facts as it relates to this matter and the nature of the allegations. But when those facts are presented in such a manner that amounts to, we say, unfairness to our client, then what is automatically going to flow is that, what flowed from this specific matter is that that unfairness simply just continued, and that the head of the civil service, yes, they considered, they read over the decision of the head of the Public Service Commission read over the decision of the head of the civil service, but that decision was filled with what we say would be prejudicial and unfair information concerning the investigation, where Ms. Bell was simply discredited.
But I mean, one of your primary points was that given this was her first offense, you say that the opinion of her co-workers was that she would just be given a sentence to the effect that she should seek help. And that's at quite a variance to summary dismissal, which, as I say, the head of the public service exercised and upheld at the Public Service Commission. I mean, they don't seem to suggest that just giving her the option to get help is the appropriate sanction in these circumstances.
Well, I accept that the head of the civil service arrived at the decision he did, and the Public Service Commission arrived at the decision they did. And obviously, at the outset of our submissions on this case, we identified the difference in treatment between Ms. Bell and whether or not it was, obviously this gives us a point of whether it's unreasonable and irrational for them to have referred her to the head of the civil service. When they thought that the matter should have been dealt with by way of counseling. So it's our submission that obviously the view of the department on the penalty is definitely relevant to the issue of whether or not the gross misconduct charge should actually have been before the head of the civil service in the first place, and whether or not the decision of the administrative body to put the matter before the head of the civil service was exercised fairly and consistent with natural justice principles and the like. So that will be our submission in relation to those specific aspects that Your Lordship raised.
Yes.
My Lord, we briefly touched on the standard of proof this morning.
Yes.
I don't necessarily see the need to revisit it now.
I see the point. You accept that ordinarily it's a civil standard of proof, a balance of on the balance of probabilities, but you say if the charge in reality is a criminal charge, then the appropriate standard is beyond reasonable doubt. Yes,
my Lord. And just obviously the case law has developed since the last amendment to this regulation, and the case law suggests that where we're dealing with matters concerning somebody's livelihood. Yes, I understand that under the regulations that it says that there's a civil standard, but there's a heightened level of the civil standard when we're dealing with gross misconduct matters and cases involving dismissals of somebody's livelihood.
Yeah, the civil standard of balance of probabilities is a continuum.
Yes.
Yes.
My Lord, we briefly just touch on the point of the penalty. It's our submission that this was an appropriate case, that if the facts amounted to a gross misconduct in which the head of the civil service has stated and upheld, that there should have been an opportunity by Ms. Bell to address the issue on the penalty. I understand that your lordship will likely raise the issue that this was fully explored before the Public Service Commission, and the Public Service Commission upheld that decision. Obviously, our view would be that in relation to this, notwithstanding the fact that the Public Service Commission upheld that decision, the appropriate test would be, would the head of the civil service have made that decision if the acting director suggested or recommended that dismissal was not appropriate, or the acting director did not want dismissal. So what we have done is in this case is that the Public Service Commission has simply reaffirmed the decision of the head of the civil service, say that that was appropriate. But what we don't have is obviously the bearing that the recommendation would have had on the head of the civil service, and whether or not the matter would have been referred to him. So yes, it's accepted that there is one case where the Public Service Commission can legitimize a penalty and say that this penalty is appropriate, but where we don't actually know if that matter would have been referred to the head of the Public Service Commission, then it's our case that the penalty is unsafe and the penalty is unlawful because there is certain material and relevant evidence that was omitted, that relevant evidence being the recommendation provided by the acting directors. And obviously it's our view that the officers that were not present would have also been able to provide relevant information on the whatever penalty should have been imposed. Obviously, the second issue in relation to this ground is that there was no second hearing in relation to the penalty. There was simply, at the head of the civil service level, there was simply a hearing that was made and then a written judgment that came out subsequently dismissing Ms. Bell. And obviously without the recommendation being present from the acting directors, we say that this is it's a dangerous precedent to set.
What was the understanding when the parties departed after the hearing? Let's concentrate on what's in the evidence.
Mm-hmm.
I mean,
so
was the understanding that there would be another hearing, or was there an understanding that simply the decision will come?
Well, my lord, it's my understanding that the understanding was that a decision would come. That the decision would come on the issue of gross misconduct, whether she was found guilty of gross misconduct. There was no discussion as it relates to what would happen in relation to the penalty.
Show me where it says that in the record.
That there was no discussion?
That this was the understanding. That the decision will come, and then there would be a subsequent hearing in relation to the sanction.
My lord, I actually haven't advanced that argument that there was going to be a subsequent hearing. What I have stated to, or my argument is solely that there wasn't a subsequent hearing, notwithstanding the fact that there was no indication that there would be.
But presumably you can only complain about it if you expected it. Otherwise, the hearing takes place, and once the hearing takes place, unless there is an expectation that there would be something further in relation to the penalty phase, there could be no legitimate complaint.
Well, my lord, we would humbly suggest that there could be a legitimate complaint because there was no recommendation that was provided. Obviously, information.
But the ultimate decision in relation to the penalty is for the head of the public service. Perfectly true.
With the recommendation.
He could have the benefit of the recommendation, but as that particular regulation provides, the ultimate decision is his. He's not bound by the recommendation.
No, he's not bound by the recommendation, but it's our submission that he could be heavily influenced by the recommendation.
Well,
That's
it's
why
conjecture, but I understand what you're saying. I mean, and we have no idea. We have no real evidence as to what the recommendation would have been,
you said,
other than hearsay evidence.
my lord, it's in that respect, I would suggest that the evidence that the court has before it is the unchallenged and uncontested evidence of Ms. Bell that was communicated to her.
Well, it's not. I mean, do you really expect the acting head to respond to an exhibited sort of messages to say whether they're correct or not? What somebody has suggested would have been the case.
Well,
I
my
mean,
lord, it's stated in Ms. Bell's affidavit. It's not just exhibited. It's actually stated in Ms. Bell's affidavit. I would expect the acting director to respond to the assertion in Ms. Bell's affidavit that the acting director believed that the appropriate penalty would have been one of counseling. That's in her first affidavit. So I understand that. I understand the reluctance of the acting director choosing not to even address that issue, because what has happened subsequent to that, obviously, it has to be, or it's our submission that if the acting director had addressed that issue, it would obviously run a coach and horse through a number of things that took place, and that the acting director, would have admitted that, or would have had to admit that she thought that the appropriate penalty was one of counseling, and that would raise issues of whether the matter was properly before the head of the civil service, and that whether the acting director took into account considerations that she should not have, and the like. But my lord, it's our submission that there is a breach where you have a serious allegations against an individual, and they aren't allowed to address the decision maker on the issue of what the penalty is to be imposed, specifically in circumstances where the code allows for recommendations to be made.
In the appeal to the Public Service Commission, did you take the point that she was not allowed the opportunity to address on the issue of penalty? I mean, obviously, you're making a big point of it. I'm just curious to find out as to whether you actually appealed on that basis to the Public Service Commission.
Although there was no appeal on that issue at the Public Service Commission level.
Why not? If it was a good point, why wasn't it appealed on that basis?
My lord, in relation to that, the only thing I can put forward in relation to that is that the BPSU representative thought that there would be an opportunity to have an oral hearing.
No, but I mean,
and perhaps there's issues.
Ms. Williams, there are 3 pages of grounds of appeal, where they say it's gone wrong, and why the decision should be different. And you're telling me that he actually didn't appeal on the basis that Ms. Bell was denied the opportunity to address the head of the public service in relation to penalty. I mean, which is an odd sort of situation if that was such a big point. And if it wasn't appealed on that basis to the Public Service Commission, why are you appealing to me?
Well, my lord, the issue before the court is whether or not the unfairness permeated as a result of the failure to do a recommendation. So it's our view. I'm appealing to the court because there is a positive obligation on these government entities, these local authorities, to do certain things. The fact that they have not done those certain things affected Ms. Bell's case. Notwithstanding the fact that Ms. Bell may not have raised it in cross-examination, or she didn't raise it in appeal, the fact is that at a bare minimum, Ms. Bell should believe that the statutory regimes and that the codes and everything would be followed. And she did not acquiesce any sort of breach or did not provide any sort of waiver, anything.
You're asking me to upset the decision of the Public Service Commission on grounds which were not argued before them.
My Lord, I'm asking the court to upset the decision of the Public Service Commission because the Public Service Commission did not exercise its duty to consider the entire matter as a whole, that being numerous faults that took place at both the administrative level and at the head of the civil service level. I understand that the submissions that were made before the head of the civil service or the Public Service Commission may not have been raised. I accept
These are intended to be the grounds of appeal. I mean, it's you are saying that I should set aside the decision of the head of the public service and the decision of the Public Services Commission, Public Service Commission, forgive me, on the basis, among other things, that they should have come to a different decision because certain people who should have provided information to the head of public service didn't do so. But that point was never taken before, as I say, before the Public Service Commission. And I mean, it is a point of substance as to whether in relation to judicial review proceedings, you can come to me and say, I should set aside a decision of a public body on a ground which was never canvassed before it.
Well, my Lord, I do know that Your Lordship did raise the point shortly before lunch, and I appreciate that Your Lordship said that he or indicated that he would afford me an opportunity to
Yes.
view the case.
I mean, it is. I mean, the point to remember about judicial review proceedings is that I'm not looking at this, on the basis of a fresh decision.
Mm-hmm.
I'm not the first instance judge to decide this issue on the merits. This is a public law hearing whereby you are attacking the decision of a public official and a public body on the basis that they did not comply with essentially the procedural requirement of how we do justice. And in relation to that, it is quite important to ascertain what exactly did you argue before the Public Service Commission?
Yes, my Lord, I accept it's important to ascertain what was argued. And just obviously, it's our submission that the failure to argue those issues at that time should not be determinative of the matter, because there is there's a certain baseline procedure that should be followed.
Well, there are cases which deal with this point, and I think council should dig them up as to whether if you are in judicial review proceedings, can you actually come and argue a point before a judge in a judicial review proceedings if that point was never taken before the appellate body?
Well, my Lord, it's a matter that depends on the facts of each case, and a lot of these decisions turn on whether or not there was new evidence that was presented. And as it relates to one aspect of, I know that Your Lordship has raised the issue of the issue of bias and whatnot. Obviously, it's our submission that that the issue of bias could not have been raised at the Public Service Commission level. I understand Your Lordship is saying that irrespective of whether or not it can be raised, the Public Service Commission determined the matter as a whole, so that there no issue of bias was no issue of bias arose. But it would be our submission that had Ms. Bell had the opportunity to know that there was a recommendation that was provided and presented that to the Public Service Commission, they would have made a different decision. That decision might have been that this matter has to be sent back and put before another adjudicator. But obviously, I'm guided by the cases of priests and the like that the court says that where there's an opportunity for an appeal for these decisions to be determined, that might assist in curing any defect in the process. My Lord, I don't wish to, and I had no intention of taking the entire day.
Well, you have. 4 o'clock.
I just wish to hasten things a bit, and I think that we've exhausted both arguments under the Public Service Commission, and that was a failure to consider the merits of the appeal. And obviously, your Lordship has identified the letter from the Public Service Commission to the letter from the BPSU representative to the Public Service Commission. Just want to flesh out just maybe 2 or 3 things in that letter. Obviously, the letter says that, and that's at page 219 of the hearing bundle.
I have it.
In accordance with clause 28(1)(b) of the Public Service Commission regulations, the Bermuda Public Service Union BPSU would like to appeal the disciplinary award. I think that the disciplinary award is a defined term in the regulations. I know that your Lordship has made comments in relation to the.
Do we have those regulations in the bundle? Oh, yes,
yes,
we do.
Yes,
we do. Yes, we do.
Your Lordship did raise this.
Tab 2.
I have it.
And this was raised in your Lordship's case that he referred me to, the case of Bowden, and whether or not the powers of the Public Service Commission, whether it was limited to the penalty or the award, was also explored in the case of Lake. But in any event, it's quite clear that they wanted to appeal the disciplinary award.
Well, what does that mean, disciplinary award? I mean, it's a one is a rather technical chancery meaning. The other one is a layman's meaning. Layman may consider disciplinary award as the penalty.
Well, it's accepted that a layman may think that, but unfortunately, without the benefit of anything further, what we have is that they're appealing the disciplinary award, and the disciplinary award is a defined term under the regulations, and that defined term has been determined to mean not only the penalty but the actual fine.
Is it right that the essentially the focus of what he's complaining about is the penalty?
Well, the focus of what he's complaining about is the penalty, yes, because it was accepted that on Ms. Bell's own evidence that she did have a drink, and that might amount to misconduct. That's what is being accepted on the.
But I mean that's quite serious. But I mean that in lawyers' terms it would mean that she accepts the conviction, but she's complaining about the sentence.
I wouldn't go as far as saying that, because what we're talking about is findings of gross misconduct versus findings of simple misconduct. So it's clear that having a drink, at least as it relates to the Department of Child and Family Services.
Well, I mean, it's actually quite interesting if you look at what Mr. Grant says on the first page. He says, in his decision, he's referring to Dr. Binns, the head of public service concluded, because Ms. Bell acknowledged that she had consumed at least 2 to 3 beers on the evening in question, She was therefore under the influence of alcohol. Multiple witnesses described Miss Bell's behavior in a manner that would be consistent with being under the influence of alcohol and therefore, as a result, was unfit for duty. And then he says this, notwithstanding the aforementioned, the BPSU would like to submit the following. And I mean, that I read as though saying that, well, let's accepting this, and here it is, the rest. Notwithstanding, he said, notwithstanding the aforementioned, the BPSU would like to submit the following. This is the first time Miss Bell has been charged with any disciplinary offences during her tenure. She has worked hard to achieve the qualifications. The penalty award is harsh considering her first offence. She and her colleagues were charged with the same offence. Although it is the opinion of the head of the public service, Miss Bell was under the influence, there is no real concrete evidence as she was never tested for the alcohol. More importantly, with this all being Miss Bell's first offence, a more appropriate penalty would be that of progressive discipline. I mean, that to me as a judge sounds like what he's complaining about is the sentence, the penalty.
Well, it's a bit of both. It's a bit of both of as it relates to the finding of gross misconduct, in that there was no concrete evidence that she was under the influence of alcohol, and this is obviously the charges being unfit for duty. So there was no concrete evidence. So and that goes to that is the determinative issue, and one of the issues where we say that obviously the relevant witnesses should have been provided.
Well, I mean, here, I mean, it's just the third paragraph up on the second page. BPSU are extremely disappointed and concerned that the head of the public service has seen fit to utilize such a harsh penalty award when there were so many other options at his disposal, especially when in the past so many offences of this nature have been given a penalty award that is more akin to progressive disciplinary process. With this being Miss Bell's first offence, this makes this judgment even more baffling. There's no doubt that because of her dedication and commitment to DCFS, Ms. Bell realizes the severity of being charged with an offence such as this. However, the penalty that she has received seems unfair and inconsistent with someone who has a clean record and has never been charged before of any wrongdoing. She has represented Bermuda internationally playing soccer and as such has a reputation for being sound character. I'm just wondering,
Last paragraph, my lord.
then she says, Miss Bell clearly deserves another chance. Against this background, we request the public service review this matter in its entirety, noting the inconsistency of sentencing, past precedents about sentencing, and seemingly unfair penalty award that has thrown a dedicated and committed public service to the unemployment line. The BPSU would like to emphatically request that Ms. Bell be reinstated to her substantive post under a more progressive disciplinary process, whereby she is given the opportunity to make amends for this ad hoc decision of poor judgment. I mean, the last sentence clearly accepts the conviction, but says that she should be given her job back with progressive disciplinary process. I mean, you wouldn't be saying that if you're appealing against conviction. You would be saying that she should have nothing against her and she doesn't deserve any disciplinary process at all.
Well, my lord, we wouldn't be saying that we're looking to appeal the disciplinary award if we're not appealing the award and simply the penalty. Also, in that last paragraph, it says, against this background, we request that the Public Service Commission review this matter in its entirety. Not review the penalty in its entirety, review the entire matter. Obviously,
Mr. Williams, if you read the entire letter, I mean,
my lord, it's accepted that the letter focuses on the issues of sentence. But just because the letter focuses on the issues of sentence doesn't mean that it dismisses the issues of the finding.
Well, read the last sentence. How is that consistent with saying that she should be acquitted of everything? How is that consistent?
But what we're dealing with is a finding of gross misconduct.
No, but I mean, if Mr. Grant is saying that I am appealing against conviction and sentence, and my primary case is that she should be acquitted of all wrongdoing, how is the last sentence in the letter on the last paragraph consistent with that position?
The last sentence in the letter is consistent with the BPSU's view that there should be no finding of gross misconduct, that a progressive disciplinary process should have been employed, and that progressive disciplinary process would have been a charge under simple misconduct. That is how I view this letter, my lord. I know that the court may have another view, but it's clear that they are challenging the fact that she was charged with gross misconduct.
So he's saying that she should be let off gross misconduct, but found guilty of misconduct.
It's our view that if the allegation is substantiated, then that the allegation on the facts of this case, as it would be a matter that would be dealt with under the misconduct procedure. It's not a matter of there being a finding, because obviously separately the issue would have to be determined, but the procedure would be one under misconduct, simple misconduct.
Yeah, where she's given an opportunity to make amends for this ad hoc decision of poor judgment. So what I mean, what's that referring to? What is he admitting in that?
That Ms. Bell drank.
That's it.
That's it.
But
Well,
no question of any conviction by the tribunals, and you're saying that this letter is to be read as Mr. Grant saying that she should be acquitted of all charges, but she accepts that she had a drink and that was bad.
This letter should be read as Mr. Grant submitting to the Public Service Commission that the matter should not have been dealt with by way of the gross misconduct procedure. That is our view. I think that is consistent with page 2 of this letter, where Mr. Grant suggests that that it was unusual for this offense to be determined in this manner in light of the past precedents. Because the past precedents did not come before the Public Service Commission. The past precedents were dealt with at the department level with the misconduct process.
Yes. Yes.
My lord, just on the issue of the regulations, under paragraph 28.2 of the regulations, where it addresses the issues of the appeal and the a disciplinary award of gross misconduct penalty has been made by the empowered persons, and then it goes to 28D, and I'm at tab 2, the grounds of appeal for a member of the, sorry. That it's 28.2 that deals with the issue of the officer may include with notice referred in a paragraph 1 any representations he wishes to bring to the attention of the commission, but unless the commission otherwise orders, neither the officer nor the empowered person who made the disciplinary award shall be entitled to appear before the commission. Now, it is accepted that the regulations states that, but obviously our submissions in relation to that is that the discretion that the Public Service Commission has to be exercised fairly and consistent with Ms. Bell's rights to a fair hearing.
Presumably, Mr. Grant was familiar with these regulations, at least. I mean, he is the union chap who presumably does these hearings on a sort of regular basis.
Well, my lord, as I stated, and it's in the evidence of Ms. Bell, that this was the 4th time that Mr. Grant had completed this this process. That being said, my lord, the submission in relation to this particular provision is that although obviously the right of an appeal and the right to be entitled to appear before the commission is at the discretion of the Public Service Commission. It's our submission that even where the Public Service Commission identifies that there are some discrepancies in the evidence, that if the Public Service Commission is to identify that there are certain discrepancies in the evidence, then obviously it's our submission, it would be difficult for the Public Service Commission to then reconcile those discrepancies. And what we have called discrepancies, it's our submission that there is clear differences in the evidence of the witnesses.
I mean, where does it say that in your notice of appeal that you're concerned about the quality of evidence?
In the notice of appeal that was filed by the Public Service Commission?
Yes.
It says in the notice of appeal that they're noting the inconsistencies in the evidence. That's what the BPSU representative stated in his letter that he wrote. He said that there are inconsistencies.
That's it? Just he said there are inconsistencies, and therefore what?
That the entire matter should be reviewed as a whole.
But I mean, we keep going back to that. I mean, what is the function of the Public Service Commission? Is it an appellate body which acts at least nominally as a courtroom, in the sense that parties come along and one party says that I want to appeal, these are my grounds of appeal, and I want to argue that these are the points which the tribunal below got it wrong, and they come along and argue it? Or is it something different where the aggrieved party simply says, I am unhappy, and throws a grenade at the Public Service Commission, and the Public Service Commission is then under a statutory duty to go around Bermuda and find out what the truth is? I mean, is that what you're saying? Or what responsibility did your client and the BPSU had to prosecute this appeal properly?
My lord, that it's our submission that there is an equal responsibility on both parties. There's a responsibility on the appellant to provide her case. Yes, there's also a responsibility on the Public Service Commission to ensure that they act fairly in determining the appeal. And what we have from the Public Service Commission as it relates to the appeal is a 2-paragraph response.
But I mean, just on that, I mean, Mr. Grant clearly had this page in his mind, because he starts off with his first sentence says, in accordance with clause 28(1)(b) of Public Service Commission. 28(1)(b) is on page 17 of the regulations, and on page 17 is also subparagraph 2, which says that unless the commission otherwise orders, neither the officer nor the empowered person who made the disciplinary award shall be entitled to appear before the commission. What did Mr. Grant say about that? Did he ask to be appeared before the commission?
Well, my lord, the evidence that we have on that is the evidence of Ms. Bell, and that the evidence was that the head of the civil service, the BPSU representative, provided a letter request that was identical, save for the facts, and at each stage, and at every time that he provided that or appealed on behalf of an officer, they were allowed a hearing.
I mean, look at it. I mean, it's, we can't just sort of ignoring the law. I mean, regulations, believe it or not, are the law. It clearly says that unless the commission otherwise orders, neither the officer nor the empowered person who made the disciplinary award shall be entitled to appear before the commission. What I'm asking you is, what did Ms. Bell and Mr. Grant ask in relation to this provision? Did they say that we would like to appear before the commission?
My lord, that has been, I think that was just discussed some time ago, and it was accepted that there was no express request to appear before the commission. That is accepted.
So how are they going to cross-examine the witnesses if they are not going to appear before the commission?
My lord, I think it's definitely easy to compound the situation with I suppose what would be the cause and effect is that if you didn't do this, then how would you do this? How would you examine the witnesses? How would they assess the evidence? How would they determine credibility? I think it's quite easy to then
No, I see that.
identify one area and then say that naturally what flows is a series of what in this case unfortunate events that the BPSU did not do. But it's our submission on, like I said, on this area that yes, it can be a fault of the BPSU, but the past precedents had been established that hearings would be held.
Well, I mean, the Public Service Commission has produced a document which is really for the benefit of those who are not lawyers, and that is the procedures governing discipline appeals to the Public Service Commission, which starts at page 222. And if you look at, and it's written in layman's language so that nobody is baffled by legal language, because it's written really for the benefit of the general public at large. It's certainly, at least I would have thought, for the benefit of the BPSU. If you look at paragraph 14, hearings on the record. All appeals shall be conducted by the Commission without an oral hearing, except with the permission of the Commission. The discipline authority may make submissions in reply to the appeal only with the permission of the Commission. A party may ask for permission to appear in person to address the panel. A request to appear in person shall be in writing and shall be made with the notice of appeal. The Commission may deny the request or grant the request to appear in person. If the Commission denies the request to appear in person, or if no request is made, the Commission may proceed to determine the appeal on the record, if the record may include any submissions of fact or law made by a party or the party's representative. I mean, in light of this, which was obviously written for the benefit of the lay public, why wasn't there a request to appear in person?
Well, my lord, I think Ms. Bell made it clear that she wasn't aware of the Public Service Commission rules and where they existed. I'm not even certain where these rules exist.
Well, we've seen the rules
for the public. For the purpose of the public, I understand as it relates to the regulation that there is.
I mean, this in effect restates the regulations in layman's language.
And so, just in relation to that, my lord, and I obviously don't want to beat a dead horse. What we have is a public service BPSU representative that has been afforded through practice, or allowed through practice to be given a hearing before the Public Service Commission without expressly requesting it.
So in this case, when the letter came saying that we're going to decide on the record, what did Mr. Grant do? On the record.
When the letter said that they were going to decide the matter on the record.
Yes. So what action did Mr. Grant take on behalf of your client?
Well, Mr. Grant didn't take any action on behalf of our client, but what Mr. Grant did do in relation to these proceedings is that he provided Ms. Bell with the the exhibits of matters where he had made a similar representation, and those matters the Public Service Commission invited him. And
So show me the letter where the Public Service Commission says that we're going to decide it on the record.
That is at page, if you go to page 75 of the hearing bundle.
So Mr. Grant's letter is dated the 6th of March.
Yes.
And some 4 weeks later on the 2nd of April 2019, he receives this letter.
Mhm.
At the meeting on Monday, 25th of March 2019, the Public Service Commission noted your correspondence of 6th of March 2019, appealing the disciplinary award handed down by the head of the public service. Given the clear evidence in this case, the Commission agreed in accordance with Section 14 of the procedure governing disciplinary appeals. That's the one we just looked at.
Yes.
Public Service Commission to review the matter on the record. It was agreed that the penalty dismissal should be affirmed, as Ms. Bell was under the influence of alcohol while carrying out her duties at residential care. So, was there any response to this by Mr. Grant?
No, my lord, there was no response to this letter by Mr.
Saying
Grant.
that this is just a complete shock because I hadn't anticipated that it would be such a summary procedure.
My lord, it's our submission that the Mr. Grant making available the letters that he's received from the Public Service Commission is evidence of the surprise that.
But I mean, this must have been
they could adopt this procedures not because they didn't request it, but because they said that there was clear evidence.
Yes, but I mean, if he was expecting a review of the evidence, if he was expecting that the witnesses would be called, and if he was expecting that he would have the opportunity to cross-examine, I mean, he would be mightily surprised, and one would expect that he would want to sort of express his feeling in fairly vigorous terms to the Commission. Did he do that?
My lord, I have no information on that, and there's no evidence before the court that he expressed his view. The evidence before the court is that that contained in Ms. Bell's third affidavit that it was a surprise that this matter was dealt with in this manner. Obviously, the Public Service Commission and the regulations say that the Public Service Commission and the decision of the Commission on Appeal shall be final. And that is at paragraph 28.5 of the regulations. I'm sure that the Bermuda, the BPSU, Mr. SU representative, Mr. Grant, was aware that the decision was final. Any comments he has to make thereafter, it's not going to sway the decision anyway. The decision is already made. Thereafter, obviously, Ms. Bell explored the option of whether or not she should pursue judicial review proceedings, and she took that exercise.
Yes.
My lord, the final pages of my submissions just deal with just some overriding principles concerning judicial review and natural justice, and I don't believe that it's necessary to read through them in detail because they're set out in my submissions, and I've identified the relevant passages in the authorities that the court has. I commend those submissions to the consideration of the court.
Yes.
I do want to just briefly touch on the decision, the need to make a proper inquiry, and that is contained at page 42, paragraph 83. And its decision makers have a basic common law duty to sufficiently acquaint themselves with relevant information, fairly presented and properly addressed. Public officials have a duty to ensure that relevant material, including the views expressed by consultees, are fairly and adequately presented to those who are the decision makers. It is their duty in turn to ensure that material is adequately considered and issues addressed. As Lord Diplock said in Tameside, the question for the court is, did the decision maker ask himself the right question and take reasonable steps to acquaint himself with the relevant information to enable him to answer it correctly? My Lord, just in relation to the duty of proper inquiry, obviously it's our submission that the proper inquiry should have taken place at the administrative level where there was discrepancies in the evidence, that the acting director should have then asked the investigating team to further explore those discrepancies. At a bare minimum, it should have been explored before the head of the civil service and the Public Service Commission. It wasn't even a relevant consideration for the Public Service Commission because they simply went off the decision of the head of the civil service. My Lord, the duty of proper inquiry includes a duty to properly consider and grapple with all the relevant material, to explore all the material evidence before it, and that would, our submission would be the inconsistencies between the evidence. This is a case where the allegation is Ms. Bell was unfit for duty, not an allegation that Ms. Bell had a drink. And being unfit for duty, I accept that the head of the civil service refuted the suggestion of the BPSU representatives that Ms. Bell discharged her duty. But in relation to that, it's our view that a proper inquiry of the matter would have confirmed that Ms. Bell did discharge her duties, and she was fit to discharge her duties and dutifully did do that. The proper inquiry includes to balance the relevant factors, not just to have them in mind, to make proper findings on important issues of fact. And we say that the issues of fact were not, there was no proper finding on the issues of fact. There was a finding, but because of the significant discrepancies, what it appears has taken place is that the head of civil service has simply picked and chose which version from the workers and the child witnesses was most appropriate in the circumstances, and did not attempt to reconcile the differences between the statements. The statements being one of vomiting, statements being that Ms. Bell left the department with a friend, where there's conflicting statements. There's conflicting statements as it relates to what worker B observes, that being that she didn't identify any difference in her behavior. These are all, this is our submission, material issues of fact that there couldn't be any proper determination without actually hearing from the witnesses and being able to assess their credibility on this specific issue. Because as I said,
is that right? You say that unless you cross-examine witnesses, you can't decide one way or the other.
Well, on issues of credibility, I think it'd be extremely difficult and it'd be unfair to decide the issues of credibility simply on a witness statement, especially where you have issues of credibility that involve disputed fact and.
I mean, the disputed facts is the head of the public service accepted the evidence of the two gentlemen who said that she told them, this is their recollection, that she had had 2 or 3 kronas. She says, I told them I had 1 or 2 kronas. So that's that discrepancy, right?
That's one discrepancy, yes.
And you say that it's not possible for a person to resolve that that little conflict on the papers by just taking into account the inherent probabilities of independent people saying one thing and one person who has an interest in the statement saying another.
Well, my lord, I think the issue that has arisen in relation to what has been recorded by the investigation team, and once again, the investigation team were officers that could have been asked to attend the hearing. the issue.
No, that's a separate issue. I mean,
I understand that's a separate issue. I just wanted to. I realized that I had not raised that earlier, but and
I mean, from a common sense point of view, I can see why she may want to sort of change her testimony to say 1 to 2 as opposed to 2 to 3. And one could say that a fact finder say, why would these two investigators who are taking down what she's told them say anything different from what they heard? They have no interest in this.
well, my lord, what you have is two investigators that have provided a summary based on certain questions that were asked.
No, I mean, in relation to that, they're basically recording what she told them.
I accept that they're recording what she told them, but what we don't have is the context, my lord. And
what context could be? The dispute is, did she say 2 or 3 coronas or 1 or 2 coronas?
my lord, the evidence is our submission that is that the applicant said she couldn't remember how much she had to drink. But since which time I have been counting how many drinks I have at a football game, and that can vary between 1 to 3 drinks. So the evidence isn't an evidence as it relates to that specific allegation. It's common in and it's discussed in one of the cases that I've referred to.
Well, no, just hold on that. She wrote to the acting head, say, I want to clarify. She in that letter, doesn't she accept that she drank?
My lord, I don't think the issue here, that at least on our end, isn't whether or not she drank. The issue is how much she drank.
Yes.
So, as we know, at least at the department level, simply admitting to having drank alcohol doesn't amount to gross misconduct. The issue, and what I understand from the acting director in her witness in her affidavit, was that she believed that Ms. Bell was unfit for duty, and the reason she didn't refer Mr. Hollis was because she didn't believe that he was unfit for duty. So the issue isn't solely the drink. The issue isn't the drinking of alcohol. The issue is for gross misconduct, whether or not she was unfit for duty.
Yes.
So as I said, the issue of drink is accepted, but this matter turned on how much she had to drink, which was disputed, and it was challenged evidence where Ms. Bell was providing a general. It's our submission. She was providing a general synopsis on what she has done, and also, my lord, the issue as it relates to the summaries is that Ms. Bell wasn't given an opportunity to even review the summaries until she appeared before the head of the civil service, and at that time she disputed it.
No,
so it wasn't like.
I accept that. I mean, we discussed that earlier this morning as to whether there was an obligation to provide her the summaries at an investigation stage. She was given a summary of the charges.
My lord, I'm not speaking of the summary of the charges or the summary of the witness summaries. I'm talking about Ms. Bell's own statement summary that they provided, not summaries from somebody else. Ms. Bell didn't have an opportunity to review her own summary that they wrote to ensure that that was an accurate depiction of what they said. Yes, the investigation team thought it appropriate and thought it important to go to record A, record B, and record C to verify the truth of their statements. At the very least, where somebody is providing a summary of in response to questions that are being asked of you, there should be at the very least an obligation on that individual to ensure that the person providing the summary reviews it, to ensure that that is an accurate depiction of what was said. My lord, the remaining of my skeleton argument just simply deals with the remedies that are available to the court if the court was of a view that the matter was unlawful, and that the decision should be quashed. And in relation to that, we rely on the McLaughlin case. And that was a matter decided by the Privy Council, where it essentially deals with the public authority being dismissed from office, and a finding that if a public, and it continues in the case of Lake, and I'll just read the passage from the Chief Justice. It follows from my finding that gross misconduct offense was not proved, there is no jurisdiction. Quashing the disciplinary award has the legal result that the applicant has never been validly, in that case, demoted. We're saying it had not been validly dismissed, and that she should be restored to her position. That's the principles outlined in McLaughlin, that where there's dismissal is void, then and unlawful.
Yes.
It's essentially not effective, and the plaintiff will be entitled to recover arrears of salary. My Lord, just in summary, just wanted to raise the following points. And obviously there's some acceptance that where procedural irregularities and breaches of natural justice arise, not every breach will amount to a unlawful decision. But it's our submission that cumulatively, this specific matter was a matter where the interview team had no authority to redact witness identities. The acting director did not obtain witness statements. Ms. Bell was not given an opportunity to review the investigation report to confirm her summary of events. Ms. Bell was not provided with copies of the witness statements and was only provided with the witnesses' summaries. Ms. Bell did not know the identity of the parties and was unable to raise any favorable points in rebuttal. The acting director did not report to the head of the civil service with a recommendation as to the penalty. It's our submission that there is obviously an issue of apparent bias under the opinion that was provided by the head of the civil service. The head of the civil service breached mandatory procedure to invite the head of the department and any other officers he included relevant, including the worker A, worker B, and Mr. Hollis, and the investigation team. There is no evidence that the head of the civil service determined the offense to the correct standard of proof. The head of the civil service did not determine the charge of, the Ms. Bell was not allowed to present submissions on the penalty. That the Public Service Commission conducted no inquiry of their own. They simply relied on the decision of the head of the civil service. The Public Service Commission did not consider, or alternatively did not consider, the merits of Ms. Bell's appeal. They chose to focus simply on the penalty, and the Public Service Commission did not afford Ms. Bell a hearing in breach of what we say was a legitimate expectation that was created through practice. It's our submission that the entire process was fatally flawed. There were decisions that were arbitrary and unreasonable in light of how these matters were dealt with, how similar matters were dealt with within the Department of Child and Family Services, such that this matter should not be before the head of the civil service. It's our submission that on the evidence at its highest and the evidence being disputed, this is the charge that may have been appropriate under the misconduct penalty, and that it should have continued under that regime, similar to the matter that was decided as it relates to Mr. Shane Hollis. Whether or not there would be a finding in that regard would have to be determined at that hearing. And obviously in relation to that, we rely on the decision of the acting director to refer the matter to the head of the civil service, obviously identifying significant discrepancies in the evidence. It's our submission that Ms. Bell should be reinstated to a former position with full pay and benefits, in line with the Privy Council decision of McLaughlin. My Lord, unless I can be of any further assistance to any specific area, those are my submissions. If you Lordship just crave your indulgence while I just take some instructions, and then I can just ensure whether or not my submissions are concluded.
Yes.
My Lord, just wanted to just reiterate one point, and that is in relation to the statement of the Public Service Commission, where it says, and that's at page 75 of the record, where it says there's clear evidence in this case. Obviously, this is a matter where the level of drink was disputed and that there was no admission that she was intoxicated and unfit for duty. So just wanted to obviously raise that issue because the Public Service Commission said that there was clear evidence. The evidence would be that she was unfit for duty and by reason of drink and alcohol. That was never admitted. So it's our submission that the evidence wouldn't be so clear on that point, at least at the public service level.
Yes.
My Lord, those are my submissions in relation to this matter.
Well, thank you very much. I think given the time, I think we should adjourn now and we should resume tomorrow morning. And I look forward to hearing from you, Ms. Sadler-Best, at 9:30.
Thank you, my lord.
And then from you, Mr. Horseman.
Yes, sir. Good evening, my lord.
Yes. So I think unless there's anything further, the hearing for today is now adjourned till tomorrow morning at 9:30.
Thank you, my Lord.
Thank you.